Right, well, good morning. It's 10 o'clock, but I think that may have been the fire alarm that we heard just now. If it starts again, I will pause. It is 10 o'clock and this planning inquiry is now open. My name is Joanna Ayres. I'm a solicitor and I'm a planning inspector appointed by the Secretary of State to hold this inquiry and to determine the appeal. This is a public inquiry. Can everyone hear me before I carry on? Yes. I'm quite good at throwing my voice, but let me know if that's a problem. This is a public inquiry for an appeal submitted following the refusal of Waverley Borough Council of a planning application for outline planning permission made by Gleeson Land Limited for the following development. Outline planning application with all matters reserved except access for up to 83 dwellings, including 24 affordable, public open space, country park, including related play space, community orchard, wildlife pond, internal access roads, footways, footpaths and drainage basins corridor. And the application was refused by the council on the 23rd of August 2004. Can everybody please make sure their mobile phones are turned off? Obviously that goes without saying, but please do that. I've double and triple checked mine, so please do the same. Now, there is, to the left of me, someone sitting up with me, who I'm sure you've all noticed. The Planning Inspectorate participates in a joint marshalling scheme with the Planning Environmental Bar Association. And as part of that scheme, I have with me this week, Miss Sarah Vernan. She is a pupil barrister at No. 5 Chambers. She has a firm knowledge of planning and the planning appeal process. But this is an opportunity for her to observe a public inquiry, essentially from the viewpoint of the inspector. She will be with me during the inquiry. Any discussions that we have will purely be about procedure rather than any merits of the case. And she takes absolutely no role in the decision-making process. Okay? So, fire evacuation procedures. I assume we won't be having another fire alarm today. Could the council explain if we're due any more this week and indeed what we should do in the event of a true fire alarm?
We shouldn't be having any further fire drills this week. In the event that there is another fire alarm going off, if we could use the 2 emergency exits, there's one here and there's one over there, follow the stairs down and then we congregate in the field beyond the car park. So go through the council's car park and there's a field beyond and that is where we congregate.
Super, thank you. Can I ask if there are any members of the press present? No, right. The event is being live streamed, so it should not be filmed or recorded in any other way unless it has previously been agreed with myself. There was a case management conference held on the 9th of December of last year to discuss the management of the case that was attended by the main parties and a representative of Farnham Town Council, and nothing other than procedural matters were discussed at that management conference. Now, before I ask for introductions, there's something that I just want to flag up. Prior to my life as a planning inspector that started in 2017, I worked as a planning solicitor in and around London for a number of borough councils. And one of those borough councils that I spent a period of time with was for Waverley. I have not maintained a personal relationship or a professional relationship. I've not come across Waverley since I joined PINS. And I wanted to flag that up in order to Frank's principles to ensure transparency. It's, as I'm sure as the advocates understand, it is a profession where you come across people time and time again, but I have made every effort to not let that happen because I take the Frank's principles very seriously, and I flag it up partly so to be open and transparent, and partly because despite the effluxion of time, there were a couple of names that I recognised previously in terms of members. So I wanted to be clear on that point. Okay, super. So now that I've given you my life history, I'd like to take the names of the formal parties to the inquiry. So please introduce yourselves and your witnesses. So I'll start with the appellant, if I may.
Good morning, Madam. My name is John Litton, King's Counsel. I represent the appellants in this case. I'm instructed by Turley Planning Consultants and I will be calling 3 witnesses through the course of this appeal. They are in this order: Mr. Philip Bell from Motion, who has put in a highways and transportation proof of evidence. Although that's not a reason for refusal for the council, that may be helpful for you and the third parties where highways issues are a particular concern. And then it will be Joanna Eade from Turley, dealing with landscape matters. And then lastly, it will be Simon Packer, also from Turley's, dealing with the planning aspects of the case.
Thank you, Mr. Liston. I confirm that I have received their proofs and the rebuttals that were submitted as well. So for Waverley Borough Council, Mr. Green, if you'd introduce yourself.
Good morning, Madam. My name is Robin Green of Council. I'm instructed by the solicitor to the Council. I have 2 witnesses, Robert Petro of Petro Harley, who will deal with landscape matters, and Christopher Sampson of KLW Limited, who will deal with all other planning matters. I hope you've received their proofs.
I have received their
Thank you,
proofs.
ma'am.
Thank you, Mr. Green. Now, there are a number of interested parties who registered to speak, and I'm very grateful to Farnham Town Council and to the interested parties themselves for being very organised and deciding who would speak and what you would speak about. I have a number of names that have been submitted during the course of the appeal preparation of people that want to speak, but I think there's an updated list that was circulating that I was informed about, but I haven't accepted yet because I suggested that the council needed to discuss that amongst themselves. So I'm happy to either call out the names that I have and then we can have a look at the list if that would be easier, possibly. I think so. Right, so if you could make yourself known to me when I call out your name, and then I will explain the process for how we will hear from you, okay? So I have Catherine Warlow, super, Miss Keeble, same person, sorry, right. So would you prefer Warlow or Keeble? Keeble. Thank you. Mr. Free. I've got Mrs. Coburn. John, and I'm terribly sorry if I pronounce this wrong, Skonigavel. Councillor Catherine Powell. David Howell. I've got here the Open Spaces Society, but I don't have an individual name, right? Julian Minto, Rebecca Clear, Tony Haslam, Joan Oldroyd, Teresa, oh sorry, no, is it Tertia Hopkins? Tertia Hopkins, thank you. And Mr. Edge. Splendid, thank you. Is there anyone else that wants to speak that I haven't called out? Yes, sir.
Stephen Tilbury for Farnham Town Council.
No, I've got Mr. Edge. No, that's fine. I think I just said Mr. Edge rather than Stuart Edge, which might have been the confusion. Okay. So other than Mr. Tilbury, was there anybody else? That's right. Splendid. And then the list of names that was circulating, which I haven't accepted because I wasn't aware if anyone else had seen it. The council had. No?
Is this a list of names that was sent to the inspectorate?
No, it was when I came in, a lady tried to give me, she came in, I think is it this? Right, okay. It's an order of people that you'd like to speak in. That's very helpful. If you could show the appellant.
I've seen that. Yes, and I mean, it's.
I haven't seen it, but just have a quick glance. Oh, that's fine. That's fine. Thank you. Yes, very helpful.
Thank you. switched off. I'm sorry. There I was, throwing my voice, not very well. If you're reading from a transcript, it's helpful for me to have a copy, either handed into the inquiry or emailed to the case officer of exactly what you say. If you can't do that, then don't worry, it's not a problem. I will take copious amounts of notes, so that's fine. When you come up to the table and sit down, I would need you to confirm your name, confirm whether you are representing yourself or anyone else, and whether you have authority to do so if you are representing a group, whether you support or object to the proposal, any qualifications that you want me to list in my decision letter, and whether you'll be happy to answer questions on your evidence that you give in your representation. You don't have to answer questions, but you should note that I can give your evidence more weight if you do so. Right, so in addition to the interested parties that want to speak, I've received a great number of representations made in response to the appeal itself and the planning application, which I have read and will of course take into account in making my decision. Word of advice to the interested parties, although I'm sure that you seem to be very organised and don't need me to say this, but I'll say it anyway. I don't need to hear the same evidence twice. That's not always helpful. So if one of your members has made the point, then you don't need to make it to me twice. I will have that note. And like I say, I'm grateful to the residents for coordinating yourselves. So thank you for that. So I've received copies of notification letters, and I've also received evidence of the site notice. So thank you for that. Plans, for certainty, the plans upon which the council made the decision are set out in the statement of common ground, and it goes through them quite comprehensively there. All core documents and evidence that I'm aware of should have already been provided. I will deal with one issue in a moment when I move on to that. And I have the core document bundle, which was agreed very early on in the proceedings. And thank you for that. I am old-fashioned and I still like paper. So that is helpful, but obviously I also have access to all the core documents on my tablet. And thank you for sending it in early as well. That was helpful. At this stage, does either party intend to submit further evidence? Or do I have everything? No?
I do have some, I suspect one of these is going to be the housekeeping matter that you probably were going to allude to, and the appendices to one of the statements of common ground, possibly. I do have an additional document, which is an update to the technical note on flooding, which is appended to Mr. Packer's proof of evidence. As you probably know, Madam, the Environment Agency updates its flood maps every quarter. And since that technical note was provided, the Environment Agency has updated its flood map. So this just reflects the most recent position from the Environment Agency.
Okay.
So it's an update to the existing technical note, effectively.
Mr. Green.
Madam, just to foreshadow what may be a new document or an updated document, we have provided to the appellant what we think is the current position on delivery, housing delivery, that is, in Farnham. I don't think the appellants have had an opportunity just to check that, but it may be that in due course you will be presented with a document that sets out the updated position.
Okay, thank you. And Mr. Litton, in reference to the appendices, we may as well deal with that now.
Yes, I think the landscape statement of common ground had or should have had 3 appendices attached to it. One of which being the agreed tree replacement plan, which possibly didn't make it their way to you. The other 2 appendices were, I think, the character appraisals, landscape character appraisals, both the wider one and also the Farnham one, but they are already in the core document, so they were available. But the plan, I think, possibly didn't make its way to you, so we have copies of that.
Super, thank you. Okay, Mr. Green, are you happy for those to be handed up?
Yes.
Super. I'm not going to mark it as an inquiry document because technically it's a missing document, so so that's fine. Okay, thank you. Okay, so I've received proof of evidence as already set out, and I will take those proofs as read. So I'd expect them. There's no reason to read them out in great detail, but of course, usual procedure applies. Take me to where you want to. Thank you for the statement of commons grounds that you were able to do. I appreciate that it was unable to complete one with the Surrey Highways Authority. I did see the email correspondence backwards and forwards.
Yes, I mean, the position is that following your indication at the CMC that you would find it helpful if there was an agreed statement. We prepared one, or Mr. Bell prepared one. It was sent to Surrey County Council. I think there were 4 chasers, the last one being on the 6th of January. We never received any response. The reason why the last chase was on the 6th of January was because it was due on the 7th of January. We haven't tried to chase subsequently.
Okay.
So we've done what we can.
Thank you, Mr. Lisson. Right, so planning conditions and the Section 106 obligation. I have a list of suggested planning conditions, and then yesterday I received an email with a final form. Now, I might be going mad, but the final condition didn't appear to have a reason stated underneath it. So if that could be checked, and I can either be told that I missed it and it was on the next page or something, or alternatively, if that could be provided, that would be helpful. In relation to the Section 106 planning obligation, the last correspondence I have in respect of that was an email that I received on the 27th of January, again with a draft form and some queries backwards and forwards, and that was sent from the appellant to the council and copied into the case officer. So is there any update on the planning obligation?
I will double check, but my understanding is it is now entirely agreed.
Which is super if it is. I just haven't.
Section 106? Can I come back to you on that?
Yeah, no, it's fine. We don't have to deal with that straight away, but it's an update today would be useful before I start trawling through. And if it has been agreed, can I have the final draft? Because the email referred to a number of clauses that may or may not.
It's certainly moved on since then.
Right.
I know that as a matter of fact. So we'll make sure that you've got the latest version.
Wonderful, thank you. Can I have a paper copy as well, please?
Of course.
Thank you. So for the benefit of interested parties or anyone that might be unfamiliar with the planning appeal process, when we talk about planning conditions and Section 106 obligation, we will have a roundtable session in relation to the proposed planning conditions, and that's timetabled for Thursday morning. It's a completely without prejudice event, so it has to happen, essentially. It does not weaken the council's position by taking part. It's one of those situations where if I were to allow the appeal, the conditions would need to be imposed, and therefore it's an opportunity for us to go through them and make sure that I would be content imposing them and that they comply with the necessary tests. Okay? So timetable wise, we're due to sit for 5 days in total, depending on this Friday in terms of site visit. I will conduct the site visit on either Thursday afternoon or Friday morning, which would be either day 3 or day 4. And we would then hear closing submissions virtually on Tuesday of next week, which would officially be day 5. Is everyone content with that?
Yes, madam. Can I just update you slightly as a result of events that happened in the end of last week and then over the weekend? I am unable to be here on Thursday because of a family bereavement, which means that I have to go to France for a funeral on Friday of this week. So I'm not available, but I've discussed this with my learned friend, and I am pretty confident that we will actually get through all the evidence in the next 2 days by the end of tomorrow. There was only, I think, 1 hour of cross-examination on Thursday morning for Mr. Packer, but I think I'm pretty confident we are going to get through the evidence, say, by the end of tomorrow, which would then leave the Section 106 and conditions on Thursday morning. I don't need to be here for those. And we can leave, if that's all right, the closing submissions to be done remotely on Tuesday, because it will give me, when I get back, a chance to then draft those.
Mr. Green?
Absolutely no objection, Madam.
Thank you. Well, Mr. Lisson, my condolences to you, but of course that's absolutely fine. So thank you for that. Right, and thank you for the draft timetable as well. It makes my life easier. So I plan to break for lunch on a daily basis around 1, or run it as a convenient break in the evidence. We'll also take mid-morning and mid-afternoon breaks. So essentially the day is broken down into 4 sessions. If any additional breaks are felt necessary by the advocates, then please, of course, let me know if that's necessary. We started at 10 this morning. For the rest of the week, we will start at 9:30. And I do not want to sit any later than, well, 5:30 at the very latest, because it's a very long day for everybody. And can the council confirm, are there any issues in the evenings of this week regarding committees and things?
Madam, yes, I'm told tonight and tomorrow night there are events in this room.
Okay. And so what time do we have a time that we were going to be kicked out?
Oh, 6:30, Madam.
If we're
so,
still here at
yeah,
6:30, we're
yeah.
in trouble. So yeah, that's fine. Thank you. Are there any, well, I think we've probably dealt with the timetable. So are any other concerns or queries regarding it? Mr. Lisson, Mr. Green? No? Super. Site visits. I travelled up yesterday and I went to have a look at the site. I went into the into Keepsake Close and parked so I could see the access. And then I went and parked in Farnham and walked up and had a wander around. So I have carried out an unaccompanied site visit. I didn't see anybody and nobody approached me. Well, I didn't see anybody to approach me, so that was fine. I will conduct an accompanied site visit this week, and the parties have submitted an itinerary for this, so thank you. I've not had any requests to view from a particular property at this stage. However, I'm mindful of the representations made by the Abbey View Residents Association in relation to the site visit. And obviously, should a particular resident wish for me to view the site from their property, then I'm happy to do that. Please put a request in and that can be tied into the site visit. Please note that the site visit is not an opportunity to provide any additional evidence to me. All the evidence has to be heard here in this room. It's purely an opportunity to point out physical features if necessary. And I might ask for something and that's fine, but it's not to be taken as an ongoing conversation of what we hear here. And that's really hard because I'm a really friendly person. So just ignore me, okay? So it's one of the flaws that I have with this. So procedure-wise, I'll outline the general procedure for the benefit of those, like I said earlier, who might not be familiar with this process. I appreciate a number of you are, so you'll just have to bear with us. So when I've concluded my opening remarks, I will invite the appellant to make an opening statement and then the council to make an opening statement. And this will help everyone to understand the main arguments of the case. I will then hear from the interested parties who have flagged up in the order proposed, so thank you for that. We will have a roundtable session in respect of highways evidence. Now, this wasn't a reason for refusal. However, there were a number of interested party representations and it was agreed at the case management conference that it would be useful to have a highways witness here. I have a few questions, so I will ask those and then I will invite interested parties who have made representations to ask questions as well. Please note they should be questions. They mustn't just be statements. It must be a question for the witness, okay? I will then move on to topic-based sessions, which are outlined in the inquiry timetable. So we will be starting with landscaping and we will then landscape, and then we'll move on to general planning evidence. For each session, the council will present their case and evidence first so that everybody can hear their objections to the proposal. The appellant's advocate will then have an opportunity to cross-examine each witness. And there will be re-examination at a later stage. I will ask the appellant to present their evidence in the same way. So again, calling their various witnesses on each topic with cross-examination by the counsel, and they have the opportunity for re-examination. Amongst all of this, I have some questions that having read the proofs and the representations and from my observations yesterday, these may be drawn out through the giving of evidence. So it may be that we get to the end of it and I don't have anything to say at all. But if I do have outstanding questions, then I will generally try to keep them to be asked when evidence isn't being given, because I don't particularly like to interrupt. I don't think that's helpful. That's just my view. I will also give those interested parties who have addressed the inquiry the opportunity to ask questions of the witnesses. Okay? Sorry, I'm addressing my comments largely at the public gallery because I'm aware that the interested parties over here have taken part more widely in the appeal process in Waverley. So when all the main issues have been dealt with, as I said, I lead a discussion on conditions and the planning obligations, standard procedure. I'm not going to repeat what I said earlier. We will then adjourn actually for the site visit, and we will reconvene on Tuesday of next week at 10 a.m. and that will be virtually. So the council will presumably set up the meeting for that and circulate the link so that you can join. There'll be no participation, there'll be no hearing of evidence next week. There may be some housekeeping issues if necessary, but it will just be for the closing statements of the council and the appellant. And if necessary, any costs applications. I'm not aware that any party intends to make a cost application at this stage. Well, certainly none has been received so far. But obviously, should that be forthcoming, then it should be done before we close, and so that the other side has the opportunity to respond. Can the parties update me as to whether or not there is an intention at this stage to submit a cost application? Mr. Lisson?
I don't have any instructions to do so at the moment. Thank you.
Thank you, Mr. Green.
Likewise, Madam.
I'm recovering from the standard winter cold, so my throat is slightly sore. Just flagging up that, of course, I also have the power to award costs against a party should they behave unreasonably, should I think it's necessary to do so. So the main issues were set out in my post-CMC note. And essentially, that's whether the appeal site is suitable in principle for the proposal, having regard to policies which direct the provision of housing, the effect of the proposal on the character and appearance of the area, the effect of the proposed access on the character and appearance of the area and living conditions of neighbouring residents, and whether the proposal would provide necessary infrastructure. That final point is due to be dealt with by way of the Section 106 planning obligation. So just a reminder about conduct. I'm sure this isn't necessary, and I've put the gravel to one side because the gravel cycle definitely won't need that, as tempting as it is. I expect all parties and all individuals present to be respectful of all of those involved in this event. This is a formal public inquiry. I appreciate planning is an emotive subject. However, I will not tolerate rudeness. I will not tolerate calling out, interrupting, or unprofessional behaviour. It's my responsibility to run this event in an efficient and effective way and to ensure that I'm able to make my decision once the inquiry is closed. Therefore, in respect of witnesses, your duty is to assist the inquiry with matters relating to your expertise. Please answer the questions clearly, stating yes or no, and then, of course, qualify your answer as necessary. Advocates, you are familiar with your duties, and I trust you to be courteous and professional and demonstrate to our pupil barrister who is watching the kind of barrister she intends to be. So is there anything else that any party wishes to raise now? Mr. Lisson?
I should just this, because it'll be relevant for the landscape evidence. When I was just reviewing the CDs, the Glivia 3 guidelines, at least the electronic version, I think stops at page 10 or 11. It's just the introductory chapter. We will be going into a little bit more of that in cross-examination. I assume that Mr. Petro has a copy of that, no doubt heavily marked. I think it has now, the online library has now been amended so that a full copy of that document is available, but it'll have to be accessed electronically.
Okay. Thank you, Mr. Lisson. Mr. Green? No, nothing to raise. Splendid. That concludes my opening remarks just before I have a coughing fit. So in that case, may I ask the appellant's advocate to make their opening statement?
This was sent to the inspectorate about 45 minutes ago. So you will have, if it hasn't reached you yet, an electronic copy, ditto to the council, I think to Mr. Green as well, but there is a hard copy. I like you, I do like paper. One more. Madam, this appeal brought by Gleeson Land relates to a site known as land south of Old Park Lane in Farnham. The appellant seeks outline planning permission for up to 83 dwellings, that's 30% affordable housing, with all other matters reserved except for the access. 8.7 hectares of open space is proposed, together with just over half a hectare of laps and leaps, far exceeding policy requirements. The proposed access is an extension to Cascade Way and Keepsake Close, forming part of the road of the existing Abbey View residential development to the southwest of the site. The technical aspects of the proposed access are approved by Surrey County Council as the highway authority, but there is an issue as to what impact those access works will have on the character and appearance of the area and the amenity of existing residents of Abbey View. The site, or the appeal site, adjoins but is outside of the built-up area boundary of Farnham and currently comprises 4 interlinked agricultural fields extending to 11.9 hectares in total. 2 public rights-of-way cross the site, footpaths 7 and 92, and footpath 94 runs east-west along the northern boundary of the site. The University for the Creative Arts, Farnham, adjoins the southern boundary of the site. The settlement hierarchy in the borough comprises 5 categories of settlement, with the highest order settlement defined as communities with key services. These comprise Farnham, Godalming, Hazelmere and Cranley. These top-tier settlements are the first focus for new housing and other development, as they have the best range of jobs, services and other facilities. However, because the borough is heavily constrained by Greenbelt and the Surrey Hills AONB, now National Landscape, the Council recognises that there is a limit to which sites within existing settlements can meet the borough's needs for new development, particularly new homes, and that the scope for expansion in Godalming and Hazelmere is more limited than in Farnham and Cranley. Thus, policy SP2 of LPP1 seeks to, and I emphasise, avoid major development on land of the highest amenity and landscape value, such as the Surrey Hills of outstanding natural beauty, to safeguard the Greenbelt, and to focus development at the 4 main settlements. That includes Farnham. The constrained nature of the borough and the council's inability to meet all of its housing needs within the existing settlements is further acknowledged in LPP1 at paragraph 6.16, which states that there is not enough suitable land for housing within existing settlements to meet the need for new homes in Waverley. Therefore, the council's strategy for housing delivery includes making selected releases of greenfield land around settlements. Most of these will be directed to Farnham and Cranley. Farnham is plainly a sustainable settlement with a wide range of shops, education facilities, health facilities and recreational facilities, all within a reasonable walking cycling distance of the proposed dwellings. And it is agreed that the site is sustainably located in relation to those facilities. Notably, the Council's reasons for refusal do not contend that the proposed development is contrary to policy SP2 of LPP1. In terms of context, there are 5 important matters providing the context for the consideration and determination of the appeal. First, the LPP1 is over 5 years old, and the Council cannot demonstrate a 5-year supply of housing land. As a consequence, paragraph 11D of the NPPF applies and deems those policies which are most important for determining the application to be out of date. Second, it is agreed that the Council's local housing needs should be calculated using the standard methodology. When the Planning Officer recommended the grant of permission in August 2024, she did so against a housing land supply then calculated to be 3.89 years. In November 2024, the Council published its 5-year housing land supply position statement. As at the base date of the 1st of April 2024, the Council's local housing need was 3,728 dwellings in the 5-year period from 2024 to 2029, or 746 dwellings per annum. This resulted in the supply of housing land falling to 2.68 years, or a shortfall of 1,730 dwellings. However, the supply has fallen still further. Applying the revised standard methodology mandated by the December 2024 NPPF, the local housing need is now 1,481 dwellings per annum. And using the Council's assumption of a deliverable supply of 1,998 dwellings, the housing land supply has fallen by a further by 1.4 years to a meagre 1.28 years. This is agreed by the Council. Third, it is agreed that the Council has under-delivered 1,413 dwellings over the period from 2013-14 to 2023-2024. Fourth, the shortfall in housing land supply is likely to persist. The Council's latest LDS, published in December 2023, this says that its Regulation 18 consultation will not start until May 2025 and has a rather optimistic adoption date of November 2027. I say optimistic because in a borough heavily constrained by Greenbelt and national landscape designations, it is going to be very hard to find sites to accommodate the 1,481 dwellings per annum now required to be delivered. In the meantime, the Council has no plan of how it will address the housing land supply shortfall in the short or medium term. This is relevant to the weight to be given to the benefits that the contribution to the housing land supply the proposed development will bring. Fifth, LPP1 does not set an affordable housing target because the Council recognises that if it were to meet the assessed need of 314 affordable dwellings per annum, the overall requirement for new homes would be 897 dwellings per annum. In other words, the Council has accepted that even with a policy requirement of 30%, it cannot deliver its affordable housing need. However, even against its target of 30% of housing completions, the Council has in fact only delivered on average 24% between 2013 and 2024. That position deteriorates if losses to the social housing stock through the right to buy and right to acquire schemes are taken into account, when the percentage falls to 17%. The net position is that over the period April 2013 to March 2023, only 900 affordable houses have been completed against a need for 3,140 affordable homes, an under-delivery of 2,238 affordable homes. To address that backlog in the next 5 years, i.e. applying the Sedgefield approach, would require the need figure to be increased to 760 affordable dwellings per annum. The result of not enough affordable housing being provided nationally is that there are now 113,000 households living in temporary accommodation. In Waverley, in 2023-2024, there were 850 households on the Council's housing register. The very substantial under-delivery of affordable housing is particularly acute, where in 2023, the median income for a full-time employee in the borough was £46,689, and the median house price was £575,000, resulting in an affordability ratio of 12.32. In 2013, the affordability ratio was 8.93. The result? 2 people on median full-time earnings paying a 10% deposit on a mortgage of 4 times their earnings cannot afford a median-priced house. Over 60% of those on a full-time median income cannot afford to rent a lower quartile property alone. Renting does not afford much of a solution. To afford a median rent requires a full-time employee to have an annual income of £47,000, and only 40 to 50% of the population can afford a median rent. This falls to 30 to 40% of all employees. 80% of 2 full-time employees would be able to rent a lower quartile property, leaving 20% unable to rent a lower quartile house. Paragraph 11D and paragraph 14 of the NPPF. The consequence of the Council's inability to demonstrate a 5-year supply of deliverable housing land is that paragraph 11D of the NPPF is engaged. This means that 1, the most relevant policies for the determination of the appeal are deemed to be out of date, and 2, the appeal should be allowed and planning permission granted unless either the application of policies in the NPPF protecting areas or assets of particular importance provide a clear reason for refusal, or B, any adverse impacts would significantly and demonstrably outweigh the benefits when assessed against the policies in the framework taken as a whole, having particular regard to key policies for directing development to sustainable locations, making effective use of land, securing well-designed places, and providing affordable homes. The present case is a paragraph 11D2 case because the proposed development does not have any impact on areas or assets of particular importance protected by the NPPF. Where it applies, paragraph 14 of the NPPF introduces a rebuttable presumption that conflict with a neighbourhood plan is likely to significantly and demonstrably outweigh the benefits. The Farnham neighbourhood plan is less than 5 years old, but only just, as it will be more than 5 years old on the 4th of April this year. It also contains policies and allocations to meet its identified housing requirement, but the needs they seek to meet is the LPP1 requirement for 590 dwellings per annum, and not the current identified housing need, which, as submitted above, has risen to 1,481 dwellings per annum as a consequence of applying the revised standard methodology. Paragraph 14B cross-references paragraphs 69 and 70 of the NPPF, which require that strategic policy-making authorities should establish a housing requirement figure for their whole area. Paragraph 78 of the NPPF requires the Council to base its housing requirement on the local housing need figure, where the local plan is more than 5 years old. The FNP seeks to meet the LPP1 housing requirement figure, 590 dwellings per annum, which is not the current standard methodology calculated figure of 1,481 dwellings per annum. The neighbourhood plan does not, therefore, meet paragraph 14B. But even if it did apply, the presumption in paragraph 14 of the NPPF should in this case be rebutted for the following reasons. 1, the neighbourhood plan housing requirement is based on a housing need figure set out within LPP1, which is out of date and very significantly below the standard methodology derived figure of 1,481 dwellings per annum. 2, the neighbourhood plan is on the cusp of being more than 5 years old. By the time a decision letter is issued, it is likely to be less than 2 or 3 weeks to being more than 5 years old, and paragraph 14 would no longer apply. 3, the increased importance placed by the government on housing delivery, with the Secretary of State and her ministers consistently re-emphasising the importance of delivering 1.5 million homes by 2029. Builders, not blockers. The housing need in Waverley is so great and the housing land supply is so small, with no prospect of the position changing anytime soon. 5, the Council's strategy, policy SP2 of LPP1, is to selectively release areas of greenfield land around settlements, in particular Farnham and Cranley. And lastly, the sites allocated by the neighbourhood plan are not delivering the houses needed. So, Madam, I then set out the issues that were identified at the CMC, and then I turned to each of those issues, the first one being the sustainability of the site in principle housing. The appeal site is outside Farnham settlement boundary set by the neighbourhood plan. Waverley Local Plan Part 2, the LPP2, allocates sites based on LPP1's spatial strategy for future housing delivery and its housing requirement. This has resulted in the release of greenbelt land and a presumption in favour of development within the defined settlement boundaries through policy DM13. There is, however, no prohibition on development outside settlement boundaries. Instead, policy RE1 of LPP1 requires that an area shown as countryside, its intrinsic beauty will be recognised and safeguarded in accordance with the NPPF. And policy DM15 of LPP2 provides that development in rural areas should not be isolated from everyday services and facilities, should maximise opportunities for walking and cycling, and recognise the natural beauty and undeveloped character which is intrinsic to the open countryside, and should locate development on areas of poorer agricultural land quality. As paragraph 3.2 of the LPP2 explains under the heading of location of development, outside settlement boundaries, whether the principle of development is acceptable will be determined on a case-by-case basis through the consideration of factors including a site's relationship with the defined settlement and the sustainability of its location. Policies SP1, SP2, ALH1 and ST1 of the local plan, Part 1 and DM15 will be of particular relevance to such applications. The Council agrees that the appeal site is in a sustainable location and that Farnham is a sustainable settlement. That is why the Council does not contend that the development of the appeal site is contrary to SP2. The Council's reasons for refusal and its case are 1, that the proposed development will have an unacceptable impact on the character and appearance of the area, or the proposed access will have an impact on the character and amenity of Keepsake Close and its residents, and secondly, that these impacts significantly and demonstrably outweigh the benefits. If they do not significantly and demonstrably outweigh the benefits, then there is a policy presumption that planning permission should be granted. It is the appellant's case. The proposed development is in accordance with the key NPPF policies directing development to sustainable locations, making effective use of land, securing well-designed places, and providing affordable homes. Moreover, the alleged harms do not come close to significantly and demonstrably outweighing the benefits. The second issue, which is the impact on the character and appearance of the area, this is at the heart of the Council's case. It is agreed that the appeal site is not in a landscape nationally designated for its beauty, such as a national landscape, nor is it part of a valued landscape for the purposes of paragraph 187A of the framework. It's also agreed that the appeal site is outside of the locally designated area of great landscape value and area of high landscape value and sensitivity. Moreover, it is agreed that the development will have no direct impact on either of these designations, notwithstanding that they were the basis for the Council's reason for refusal 1. The only locally designated landscape area the appeal site falls within is an area of strategic visual importance, ASVI. Although the Council now contends that the proposed development will have an impact on the ASVI, it is agreed that harm to the ASVI was not identified in the Council's reasons for refusal. The Council agrees that the appellant's LVA, Landscape and Visual Assessment, was prepared in accordance with best practice as set out in Glivia 3, and the methodology and representative viewpoints are also agreed. The differences between the respective landscapes are relatively narrow. It is agreed that the proposed development will have an adverse landscape and visual impact on the appeal site, but that the impacts on the wider countryside away from the appeal site would be limited. Thus, the differences relate to the level of 1, the landscape effects on the appeal site, and 2, the visual effects on the users of some of the footpaths. These differences are set out in the tables at Appendix 4 to the Landscape Statement of Common Ground and will be considered in the oral evidence. The other aspect of the Council's concern is in relation to the impact of the proposed access on the character and appearance of Keepsake Close and the amenity of existing residents of Abbey View. However, it is now agreed that, and I quote, the proposed tree replacement strategy, Appendix 3, would allow for like replacement of the street trees that can be conditioned accordingly. This would provide satisfactory mitigation for the anticipated adverse effects. Thus, the only issue relating to the proposed access is the impact on the amenity of existing residents of Abbey View. Turning to the effects on residential amenity, notwithstanding that the Council's landscape witness has agreed that the tree replacement strategy will provide satisfactory mitigation to the adverse effects on the character and appearance of Keepsake Close and Cascade Way, the Council's planning witness inconsistently asserts that the proposed access works will have a detrimental effect on the street scene, principally through the reduction in the width of the verge. So far as the impact on residential amenity is concerned, the objection is general in nature and arises from an increase in traffic using the northern end of Keepsake Close, resulting in some disturbance from noise and car headlights, although the impact of headlights appears to be limited to number 18 Keepsake Close. In terms of the fourth issue, a Section 106 agreement has been agreed with the Council, and the Council has accepted that reason for refusal 3 falls away on the completion of that agreement. And then just briefly under other matters, at the case management conference, we raised the possibility of an alternative mitigation strategy to making a financial payment to the existing SANG, and a proof of evidence was submitted to support that alternative strategy. However, we are no longer pursuing that alternative strategy, and this has now fallen away. So instead, we have reverted to the original proposal of making a financial contribution, and this is now secured through the Section 106 agreement. Thank you, Madam.
Just in terms of inquiry documents, I am keeping a note of them. So I have taken the proposed order as an inquiry document because it's there and it actually helpfully sets it out. So Mr. Litton's opening is inquiry document 2, and Mr. Green, yours will be inquiry document 3. When we finish the hearing of evidence and everything, I will circulate the list of inquiry documents as I know them to be, so that when preparing your closings, you have them to hand and we're not at odds. Okay. So thank you for that. Mr. Green, if you would like to do your opening statement on behalf of the Council.
Madam, this appeal concerns outline proposals for the erection of up to 83 dwellings, of which 30% would be affordable, the provision of public open space and other ancillary development on 4 fields in the countryside, immediately to the north of Farnham and west of Farnham Castle. Following a site visit, members refused planning permission because the development would be contrary to the spatial strategy in the Farnham neighbourhood plan, would cause harm to the character and appearance of the area, would be detrimental to the amenity and quality of life of residents near the proposed access, and was not supported by an appropriate planning obligation. The last of these objections can be overcome, the remainder cannot. The neighbourhood plan was made in April 2020, and it allocates a number of sites for residential development to meet, indeed exceed, the need for new housing in Farnham identified at the time. To protect the countryside around Farnham, it also defines a built-up area boundary and restricts development beyond it to certain specific categories. As is common ground, the appeal scheme is not one of the permitted categories. Accordingly, the proposals are clearly contrary to the housing and countryside policies of the development plan. The development of a housing estate on fields currently used for grazing will inevitably harm the character and appearance of the area. The appeal site is crossed and skirted by well-used public footpaths, and local residents would also see the development from their properties. Again, it's common ground that the appeal scheme would cause landscape and visual harm, although the parties disagree about the extent of harm. The creation of an access to the appeal site along Keepsake Close and Cascade Way through what is currently a quiet cul-de-sac would also harm the amenity of residents along those roads through physical changes to enlarge the carriageway and the substantial increase in traffic that would use the access. There would be other adverse effects as well, although none sufficient to warrant the refusal of permission on its own. The development would impinge on the setting of St Andrew's Church, listed at Grade 1, affecting views of its tower. There would also be a loss of best and most versatile agricultural land. Against this, the appellant points to the undoubted need for more housing, market and affordable, in the borough, and the significant shortfall in the housing land supply for Waverley. Applying the latest methodology mandated by government, the council has only 1.28 years of housing land supply. And in these circumstances, the National Planning Policy Framework tells us that development plan housing policies are deemed to be out of date. Ordinarily, this would result in a presumption in favour of the grant of planning permission, unless the harms significantly and demonstrably outweighed the benefits. Where, however, there is a neighbourhood plan in force that is less than 5 years old, and it makes allocations to meet its identified need, the presumption is the other way. The adverse impact of allowing development that conflicts with the neighbourhood plan is deemed likely to significantly and demonstrably outweigh the benefits. That is the situation here. The proposed development is contrary to the development plan and in particular the neighbourhood plan. It would inevitably cause harm to the landscape and its visual qualities. It would also harm local residential amenity and living conditions and have other adverse impacts as well. The council recognises the contribution the site could make to the housing needs of the borough and other benefits that would flow from the proposals, but it considers that the balance tilts clearly against the grant of planning permission. Accordingly, it remains opposed to this appeal.
Thank you, Mr. Green. Okay, so turning then to representations from interested parties, I think what I'm going to do is a number are proposed within the order here, and then I can see, and correct me if I'm wrong, because I just made a note of this whilst I've been up here, but I think Mrs. Coburn, Mr. Tilbury, Mr. Howell, and the Open Spaces Society are not within the proposed order. Is that correct?
Sorry, could you speak up a little bit?
I understand that the Open Spaces Society is not within the proposed order of the interested parties that have put forward.
Sorry, I really can't hear properly.
It's not. It's fine. Okay, so I propose to take in the following order the representations from Mrs. Coburn and then Mr. Tilbury. Yes, unless there's a particular way you'd like to do.
Yeah, sorry to interrupt, Madam. It's just that it's probably better if I go after Mr. Tilbury
Okay.
and try not to repeat.
Okay.
Make separate points.
No, that's fine.
Okay.
I just thought my rationale is that being on the town council and whatnot, you're slightly possibly more experienced than some of the members of the public that wish to speak. And so it might be helpful to them for you to go first. So Mr. Tilbury, if you would like to go first, and then I will take Mrs. Coburn, and then I intend to hear Mr. Howell, and then the Open Spaces Society, and then I will hear from the list that's proposed here. Okay, thank you. Could somebody assist, perhaps someone from the council could assist Mr Tilbury with the microphones? Thank you. Mr Tilbury, you're more than welcome to sit behind and then, yeah, and use those, that's fine. For the purposes of evidence this afternoon, we will need the microphones on the round table working. Unless, well, I don't mind, to be honest. What, do the advocates have a view on where people sit? Yeah. Mr Green, do you? Okay, fine, that's absolutely fine. So, Mr Tilbury, if you could confirm your name, whether you're representing anyone or a group, and whether you have the authority to do so, whether you support or object to the proposed development, any qualifications that you want recording, and whether you'll be happy to answer questions on your evidence, please.
Thank you, Madam. So my name is Stephen Tilbury. I'm here on the authority of Farnham Town Council to make their representation. I'm not giving you evidence as an expert witness. I'm giving you their interested party representation. And I should say that we prepared this before we had the updated information regarding the SANGs. So I'm going to read out what we've written as written, but obviously it's slightly overtaken by events in that context. And I have hard copies available. Farnham Town Council supports the reasons given for the refusal of this application and asks you to dismiss the appeal. As the appellant acknowledges the proposal is in conflict with important policies in the development plan, it is not limited, as the appellant suggests. It's a full-on conflict with policy FNP 10 because the site is outside of the built-up area boundary and lies in open countryside. It's not an allocated site in policy FNP 14. That would be an important consideration in any circumstances, but is all the more so here because paragraph 14 of the MPPF makes clear the in principle harm which arises from allowing development which conflicts with the policies of a qualifying neighbourhood plan must be considered of great importance in decision making. As the MPPF says, it is likely to significantly and demonstrably outweigh any benefits that may be on the other side of the planning balance. As such, it's a direct counterweight to para 11D and surely intended to reinforce the importance of the plan-led approach by restoring the primacy of the development plan in the form of a qualifying neighbourhood plan in situations where the tilted balance applies. Our neighbourhood plan was produced by a responsible public authority taking seriously its role in the planning system. The review which led to the current plan was initiated specifically to ensure that sufficient sites were allocated to meet the updated housing requirement, which crystallised when Part 1 of the Waverley Local Plan was adopted in 2018. Farnham has been willing to accommodate substantial new development and will no doubt make plans to do so in the future, but not unreasonably, it wants there to be a plan-led approach to where it will go. If public confidence in the planning-led system is to be maintained, the purpose and intention of paragraph 14 must be given its proper weight. The appellant is sufficiently concerned about this to invite you to disregard para 14 on the basis that the Farnham neighbourhood plan does not meet the qualifying criteria. In our view, their argument's wrong and paragraph 14 is fully engaged. The error, as we see it, is for the appellant to conflate the housing requirement of the local planning authority, which can change, of course, with a housing requirement for a neighbourhood plan, which can only be identified at the time the neighbourhood plan is made. The wording of para 14 is very specific. It says the neighbourhood plan contains policies and allocations to meet its identified housing requirement. It must surely mean that of the neighbourhood plan area and not the whole local plan area, and can only be the housing requirement identified at the time the neighbourhood plan is examined and made, not some subsequent figure about which it can have no foreknowledge. We believe that the test of the neighbourhood plan has to pass for para 14 to be engaged, in addition to the 5-year rule, simply was a housing requirement identified at the time the plan was made, which is where paras 16, 9 and 70 of the MPPF are relevant, And were sites allocated to meet that requirement? The answer to both questions, as confirmed by the examiner's report on the neighbourhood plan, is yes. And since the plan is less than 5 years old, Para 14 is live and must form part of your judgment about this proposal. Turning to specific issues, our view is that the development on the site would be harmful to the landscape setting and character of the town. We believe there is an obvious and natural edge to the urban area, and that breaching this boundary would be harmful. In our judgment, the appellant's verified views demonstrate the way in which housing would advance up into open countryside rather than settling along the natural boundary. The argument that the site is well contained and the landscape impact would be limited is not one we share, nor is it the council's expert witness whose evidence you will hear. The Abbey View development was carefully designed to ensure the relationship between roads, footways, landscaping and house plots was well defined and safely laid out. The appellant's landscape consultant describes it favourably as well-designed new residential neighbourhood with a strong framework of green infrastructure features. It's now proposed to make changes that will compromise that layout, altering footway widths, the relationship of housing plots to the highway and removing newly planted trees. The scale of these changes may seem modest to the appellant, but it's less so to those who will live through traffic their development was never intended to accommodate. Although no reason for refusal was given relating to flood risk, we remain concerned that the information provided and the assessment made may not adequately address the risk posed, particularly from surface water management. After lengthy discussions with the local lead flood authority, the appellant has been forced to adopt a solution which differs markedly from their original proposal, which relies on flow rates they did not originally propose. Please bear in mind that properties in Abbey View have suffered from flooding problems which were not anticipated or designed out by the technical assessments for that development. There is real concern that this will happen again, and we need to be absolutely certain that the proposed solution will work not just on the day it's installed, but for years to come. The provision of SANGs to mitigate the impact on the Thames Basin and Heath SPA is also required, and of course it's for you to consider this as part of your appropriate assessment. The appellant wants to keep two options open. One is to purchase capacity from the site at the Church Crookham, a solution which technically meets the natural inland requirements for SANG's provision, but the Abbey View development adopted the same approach, and we'd have been interested to see any evidence which demonstrates that residents do actually visit Church Crookham on a regular basis for recreational purposes. In other words, whether the policy actually works. Alternatively, the option of the SANG's provision on site has been raised, which we've heard has now fallen away. The question is, does the proposed mitigation tick a box, or is it something which would actually prove effective? Madam, this application is in conflict with the development plan policies contained in the Farnham neighbourhood plan, and paragraph 14 of the NPPF gives you guidance on how to deal with that conflict. That the neighbourhood plan is a detailed and constructive response to meeting its housing requirements should give you confidence that the town acts with a responsible approach to the town-led system. It will no doubt make further allocations if and when it's possible for it to do so. In the meantime, allowing speculative development contrary to the policies of the neighbourhood plan, which meets the requirements of para 14 of the NPPF, is clearly not what the government intends, even in the ongoing push for housing delivery. And we hope you will dismiss the appeal on that basis, as well as for other reasons.
Thank you, Mr. Tilbury. Are you happy to take some questions if the appellant has any? Mr. Lisson?
I don't have any, thank you.
Don't have any questions. I was going to ask something about that you mentioned in respect of flooding. However, I can see that Tertia Hopkins will be talking about that in her representation, so I think I might reserve that and ask her if I still need to. Thank you, Mr. Tilbury. I've taken Mr. Tilbury's representation as inquiry document 4. Right, so Mrs. Coburn, if you would like to come up to the same place as Mr. Tilbury, please. Like I said, I do hope that we'll be all right with the witness here. I'm mindful that if interested parties want to ask questions, then they're to their back. Whereas I know a colleague of mine was here a few weeks ago, on and off, and I think they had people sort of move so that the interested parties were facing them. So if preferable today, I think I would prefer the mic situation to be resolved so that we can have witnesses here. Otherwise, I think it's quite difficult should interested parties want to ask questions later on. All right, but for now, we'll stay where we are. Welcome, Mrs. Coburn. Thank you. So, same questions. Would you please confirm your name, whether you're representing anyone or any group, and if you have the authority to do so, whether you support or object to the proposed development, any qualifications that you would like recording, and whether you'll be happy to answer any questions that the appellant's barrister may have.
Thank you, Madam. I'm Councillor Carol Coburn. I'm a member of the Waverley Planning Committee and have been for many years. I also chaired the group that wrote the first Farnham neighbourhood plan and then reviewed the plan in 2020. I'm speaking personally, but with that experience, I'm against the proposal for various reasons, but I will try not to repeat what Mr. Tilbury has said. A little bit difficult. Have I answered all the?
Yes.
Yes. Oh, yes. Yes. Thank you, Madam. Yes, what I really would like to do here is to stress the robustness of the process of the neighbourhood plan, because it is a plan that was started in 2012. Many of the people in the gallery and sitting behind me have been part of this process, and it's an ongoing process and a process that really involved the whole of the town, because we wanted to get what we were putting into the plan correct. So nothing that is in this plan was just put in on a whim. It was all done working with experts in the field where we don't have the expertise, working obviously with the Borough Council, and it has been tested, those of you who know the history, twice at referendum and once in the courts. And our site selection was found to be robust and fair, which was the important thing. So the delegation of site selection was made at the local plan part 1 inquiry. The inspector at that inquiry delegated all responsibility for site selection to Farnham. Obviously, we worked, the biggest site at the moment was a strategic site at Waverley, and it's now being built out. We put it into the neighbourhood plan. But we worked with the borough on the choice of sites, so that if they had a strategic site, we would see whether or not it fitted our criteria. If you look at the FMP, pages 42 to 44, you will understand a little of why we think this particular site should not be included within the built-up area boundary. The built-up area boundary, it is fully compliant with the local plan policy SP2. It isn't a fixed boundary that we just sort of plucked out of some old documents. We looked completely at brownfield sites in the town and at greenfield sites in the town, and worked out where development would be possible. We didn't count it. We didn't do it backwards. We didn't say, oh, we need 2780. Let's see where we put them. We looked at the sites, greenfield and brownfield, and came up with the figure that's in, including windfalls, of 3005. So the built-up area boundary was drawn round the existing form and also the proposed sites, which are greenfield. So we have done as a settlement what we were asked to do, which was supply sites, to identify sites, greenfield and brownfield, that would be acceptable for development. This one, because of its history, this particular site, the old park is obviously, as its name suggests, the original park that was part of the castle, and the new park, or just Farnham Park as we now call it, was just that, new. And all of that area is a setting for the castle. If you look, and for St Andrew's Church, and one thing the ASVI has always tried to do is to keep these views, so the view from the castle to the church and back, because of the historic importance of the castle, which, as most of you probably know, was home to the bishops of Winchester. It was a well-known centre for the church at the time. So when we, as I say, looked at the sites, we looked at them from a variety of reasons, but we didn't do any of them without a great deal of thought. So we drew the boundary round the new development at Cascade Way, Abbey View, and that meant that we had a neat ending, if you like, to the town, to the settlement, and then into the old park, which, for all the reasons listed on 42 to 44, we decided had to be protected. It comes under FNP 10E, but in fact, the other parts of FNP 10 protect it because it is a special, as we're concerned, landscape. Doesn't have national designation, we appreciate that, but it does have ASVI, and it is a crucial setting, if you like, of the castle. And the castle is the heart of Farnham in every sense, you know, as you come into it. So we are fully compliant with the local plan, otherwise we wouldn't have been accepted. We have done everything that we have to do to find these sites. And I have to say, I am with Mr. Tilbury completely on paragraph 14. It cannot make any sense to have a paragraph 14 which has put into process the, if you like, the grace period of a neighbourhood plan to prove that it's delivering houses, as indeed this plan is and has been ever since it was born and continues to do so. Sites are still coming in. And if you say, well, you know, paragraph 14 says you do have this grace period, but let's tear it up because, yes, the borough doesn't have a 5-year house and land supply. I think you are just going to destroy the whole point of paragraph 14, you know, because it says there quite rightly, and you can't keep changing. We have to review the plan. We'll be reviewing it at the moment. It's being reviewed at the town council. We know that's going to be a necessity, but you've got this 5-year grace period. And I think from the point of view of the public who have supported this all the way through and the borough, we should maintain that the local plan policies at the moment do protect this site and should protect this site. Just a brief mention of updated FNP 12. When we did the first one, we didn't have a particularly strong feeling on SANG, you know, in terms of policy, but we have updated that to make sure that the SANG works. And Mr. Tilbury touched on this. I won't go into any more detail. So we feel that this old park, the map F in the neighbourhood plan, pages 42 to 44, FNP 10E, fully compliant with SP2. We think paragraph 14 is appropriate. And we as a town, and certainly as a neighbourhood planning group, would not support development on this site. Thank you, Madam.
Thank you, Councillor Coburn. Mr. Liston, did you have any questions?
No, thank you.
No. I don't have any questions, so thank you for your representation. Sorry, Mr. Green, did you have any questions? It's not normal for the but in the interest of fairness. Right, thank you. So I'm now going to hear from Mr. Howell, if I may.
Hello, ma'am. I registered to speak if I needed to.
Right.
In this case, I won't at this moment, but I may like to ask some questions of the witnesses later.
Thank you, Mr. Howell. Okay, so then I'd like to speak, no, I wouldn't like to speak. I'd like to hear from the representative of the Open Spaces Society, please. Thank you. Welcome, Mr. Mipro. Is that correct pronunciation?
That's my qualification. I'm a member of the Institute of Public Rights Away and Public
Mr.
Access
Milson.
Management.
Apologies. I apologise, Mr. Milson. Welcome, Mr. Milson. So same questions, if you could confirm them for me for completeness. So your name, which we've just got to, whether you are representing anywhere or any group, which I understand is the Open Spaces Society, whether you support or object to the proposed development, any qualifications, which I now have, and whether you'll be happy to answer questions on your evidence.
Yes, my name is Bob Milton. I'm a qualified consultant on rights of way and common land and a member of the Institute of Public Rights Away. I'm objecting on behalf of the Open Spaces Society and make the following comments on the plans themselves. I will just go through the list here. All footpaths and bridle paths, including linksways, should be subject to statutory protection by being entered on a definitive map and statement for highways and rights of way. This is to protect the public rights in perpetuity. The existing public bridleway and footpath network, which includes bridleway 185 Old Park Lane, footpaths 7, 94, 92 and 5, must be protected and enhanced rather than being made just footpaths, footways or carriageways. This is to maintain the safety of vulnerable highway users, especially cyclists. All the public open space should be subject to statutory regulation by being entered on the Village Green Register or subject to the Open Spaces Act 1906, so they have statutory protection in perpetuity. Any extended use of the public highway should be sufficient to accommodate all vulnerable non-motorised user traffic. The reason is to protect vulnerable road users, especially cyclists. I am aware that these issues can be dealt with by planning conditions and will be pleased to attend on Thursday for the round table.
Thank you, Mr. Milton. Mr. Liston, did you have any questions?
Only really matter of clarification. I mean, you've made a series of statements here, Mr. Milton, about the status, the legal status of these various footpaths, etc. I mean, there's no intention of the appellant that they should change their legal status. So I'm not entirely sure what it is, the point that you're making, for example, at point 2, which is that byway 185 and then footpaths 7, 94, 92 and 5 must be protected and enhanced rather than being made footpaths, footways or carriageways. I mean, if they are footpaths, then their use is restricted to foot users. They are not byways open to all traffic, which cyclists can use. And we're not proposing to change the status of any of that.
There's no reference in what I've just said to byways at all. Byways reflect motorised traffic. I haven't mentioned that at all.
BW 185, what is that?
Bridleway 185.
Bridleway.
Not byway.
Okay, but well, my point is I'm not entirely sure what is the point you're making here, because we are not proposing to change the status of any of these rights of way.
Yeah. It's twofold, really. One is there will be, because of the development within Farnham and the proximity to the college, an uplift in requirements for cyclists. Cyclists do not have a public right to use the footpaths. And what you will get, because of the narrowness of the footpaths, you will get conflict between unlawful cycling and whether it's going to college or wherever, and linking with the existing bridleway network. The rights-of-way improvement plan, both as is and as is in draft with Surrey County Council, calls for enhancement and benefit to the public at large. This plan does not give that.
This plan, this
Your
is Surrey
plan.
County. Oh,
No.
I see. This development.
This development plan.
So is your point that you're concerned that there may be a conflict between pedestrians or footpath users on foot and cyclists? Is that the point?
There will be.
Okay, well, now I've understood the point. I'll ask Mr. Bell to address that. Thank you.
And the same applies to the in perpetuity issues where there is no, SANGs do not have in perpetuity status. They are regulatory issues and apply for, and it's 80 years, whereas village greens are in perpetuity subject to the will of Parliament. We have seen a number of developments where regulatory conditions have been dealt with outside of statutory regulations and are subject to local authority changes. And we'd seen one in Fleet where they took, because it wasn't statutorily, not registered in the Village Green register, was taken for planning for more housing, even though there was a 106 agreement.
All right, this is a completely separate point now to the conflict between cyclists.
It's covered. This is why number 3 is there.
I see. Okay. So your concern is what? That the SANGs that we're making a contribution to might change its status?
I'm really referring to the fact that you've got public open space, which has no statutory protection.
I see. So your concern is that the 8.5 hectares of public open space that we're providing doesn't have any statutory protection.
Has no statutory protection.
Okay, all right.
And we would call for it to be statutory protected, either by registering it as Village Green or under the Open Spaces Act.
Okay, I've understood the point now. Thank you.
Mr. Nielsen, can I just ask a point of clarification? So in respect of the public open space and your point that that should be registered, that's a succinct point. Are you also raising a SANG point generally in terms of the contribution to the SANG at Church Crookham, or are you not raising that? Is it just site specific for the open space?
This is site specific to this site. SANGs is another matter completely and relates to what we consider indirect taxation. So it's not really relevant. It doesn't affect statutory rights.
Thank you for clarifying that. I don't have any further questions. Mr. Green, no, right, splendid. Thank you, Mr. Milton. And I've taken Mr. Milton's representation as ID 5, inquiry document 5. Okay. Right, so moving on to the proposed order of interested parties that wanted to speak then. And first up, I have Mr. I'm going to say Sconegavel. Is that correct or is that wildly wrong? I'm so sorry. Ah, okay. Good to know. Thank you. So, oh, that's well. Perhaps if the council and Thank you. So again, if you could confirm your name, which we've just been done on the way up, whether you're representing yourself or a group, supporting or objecting to the proposed development, any qualifications you want recording, unless of course they're in your representation, and whether you'll be happy to answer questions on your evidence. And then please, when you're happy to.
Okay, thank you. So my name is John Skinnerkival. I'm representing myself. I object to the proposal, and I'm happy to take questions. I am the former chair of the Abbey View Residents Association. So I contend that paragraph 9 of the final statement that was submitted by Gleeson, where they were rebutting the arguments, fails to address the impact of the changes to the roads on the Abbey View development and its effect on the residents. When Taylor Wimpey submitted their application for planning permission for the Abbey View development, the company included a document titled the Design Rationale Section 8. And in my submission, I have included an image from that document here. That document was a key part of the proposal that was approved and adopted by Waverley Council on the 14th of February 2018. And it provides information on key elements of the design for Abbey View. It confirms that agreed core principles included that the landscaping and open space would have a village green approach with the need for more frontage and vista into the site from the southwest approach. As stated on image 8.1, this is taken from that, the landscaping reflects the existing character of the settlement through the creation of a well-landscaped entrance with a village green feel created through enlarged grass verges and tree planting. The proposed changes to the access roads to Cascade Way and to Keepsake Close would destroy this village green feel and are therefore surely not reasonable. Additionally, in the centre of the junction between Keepsake Close and Pioneer and Cascade Way, there is what they call a focal square feature with strong planted frontages. This will be affected because the widening of the roads will mean that the roads dominate and thus ruin the balance intended between the hard and soft landscaping. Furthermore, to actually gain approval, the original plans submitted by Taylor Wimpey were altered and a significant reduction in roads was made to provide softer, wider edges without compromising pedestrian street movement. Some 5 years after planting, the trees are starting to mature. Gleeson's plans show that they will remove these trees, and yes, they'll eventually replace them with new but immature ones. This will add to the damage to the street visuals for many years to come. The approved design criteria included local roads at 4.8 metres wide, which were considered adequate for 120 dwellings landscaped with trees to create a sense of enclosure with a distinctive feel and an ambience created by soft landscaping and pedestrian walkways. This design encourages slower moving vehicles because there is just enough room to pass. It prioritizes walking and thus facilitates safe access for adults and children using the open green spaces. The Gleeson development would also have an adverse impact on what's called the key walking route through the site and cut across the existing grassed and planted safe access pedestrian route between the east and west parts of Abbey View across the end of Keepsake Close. The effect of widening the roads is contrary to the latest Healthy Streets Design Guide, where compliance requirements aim to preserve the character and environmental landscape of the development. I therefore submit that the road widening and extension changes proposed by Gleeson materially and adversely affect all of the above and run counter to the approved design principles. I and the others moved to this development because we accepted the developer's proposals as described above, and also that the landscaping and open space was protected by a strong Farnham neighbourhood plan, which gave reassurance for people moving into Abbey View that it provided for the sustainability and easy walking for the many retirees and families and the families attending local schools. Prioritise walking and cycling with motor transport at the bottom of the movement triangle, similar to the Healthy Streets Design Guide for Surrey, is now an operational document for all construction activities, and I submit this goes against that. Abbey View is a quiet neighbourhood where communities engage with each other as per the design intent. This would be ruined if access through the estate were to be approved. As a founding member of the AVRA committee, I was heavily involved in our efforts to get the estate finished to an acceptable standard in order that the management company could start to maintain the landscaping. This took 3 years of dedicated efforts by the committee, with Taylor Wimpey prevaricating and frequently delaying in delivering on its commitments. All this will have been wasted if this road widening application is approved. It's unreasonable to the construction period will take several years. Based on our experience, we'll then be faced with many more years of work to get the developer to actually complete on their obligations. Further and finally, there is a more reasonable and appropriate access route for the proposed development, which is through the University Access Road. That road is already wide enough, has less impact on nearby residential properties, and would completely avoid the disruption and impact on residents of Abbey View for this and any further development beyond the Gleeson proposal. If Gleeson were to be approved, then it should surely be using this access route as it would have the least impact on the neighbourhood. That's the end of my submission.
Thank you very much. Mr. Liston, do you have any questions?
No, thank you very much.
I think I appreciate we're still sort of halfway through interested parties, but I think given the time, a short break would be helpful. So it's 11:38. So I'd say we'll adjourn and then reconvene at 11:55. Okay. And this is inquiry document 6, just before we step away from it.
Thank you very much. Chris. Good stuff. Someone might be looking at these? Yeah, although it may not be until the right. Okay, didn't expect to get some new fancy model, not only Yes. Then it's just a case of plugging them in. I've got these. Testing. Hello. That's fine.
These benefits. Oh, do you know what? I'm just going to grab my bag because so many, and I'm stealing my car keys. Right, welcome back, everyone. So we will continue hearing from the interested parties. I have a document on my desk. Have you seen this, Mr. Lisson, Mr. Green?
Yes.
Weight to be given to benefits, disbenefits.
Yes, Madam, it's just a table intended to assist you by summarising the weight attached by the parties to different factors.
Okay. And is it agreed by you, Mr. Lisson, for it to be submitted? Yes. Yes. Right, thank you. And before we go on, I just wanted to clarify, I've received an email with your openings, so thank you very much. And I've received the email with the complete statement of common ground with all the appendices attached to it. So thank you as well for that. They've both come in. Right, so moving on then with our representations from interested parties. So the next person I have to speak is Tertia Hopkins. So Ms. Hopkins, whilst you get comfortable, again, the same questions. So confirm your name, whether you're representing yourself or anyone else and your authority to do so if you are, supporting or objecting to the proposed development, any qualifications you'd like me to record, and whether you're happy to answer questions, and then please carry on at your own pace.
So it's still good morning. So good morning, everyone. I'm Tertia Hopkins, actually Hopkins Sarai. I'm here representing myself today and my partner who is in the gallery on personal matters relating to flood issues. We are the homeowners of 13 Keepsake Close. I am against the proposal. I am happy to take questions, but I might have to call on my partner who did most of the wrangling with Taylor Wimpey to sort out all of the flooding issues. So just be aware of that. Was that all the questions answered?
Are you happy to? Okay,
Yeah.
So no, that's fine.
Okay, perfect. All right. So since purchasing our property on Keepsake Close in December 2020, we have experienced recurrent flooding issues due to the insufficient drainage and surface water management on the Abbey View site. Our property, situated at the lower end of the proposed development site near the flood corridor, has been frequently subjected to surface water flooding. This has led to considerable waterlogging issues in our garden and water ingress into the garage, causing major damage and also major disruption while Taylor Wimpey was trying to resolve these issues. Despite some success in addressing the garage flooding issues, which took well over a year, the garden continued to experience persistent flooding, requiring us to make quite significant financial investments into trying to resolve these issues. I'll mention a few examples. Over the course of the last few years, we've had to drill various boreholes in the garden, especially in the areas that suffered most of the waterlogging issues, to try and determine whether the water was actually draining. And I can tell you that after 2 months, it didn't. We also did extensive landscaping work to level out the garden, and which included removing tons of clay. We also eventually did deep soil aeration to crack the clay about 1 meter below ground to try and create a natural soakaway for the water. I'm sure you can understand that this ordeal has been very disruptive since we've moved in, distressing, time-consuming, and financially burdensome. A stark contrast to the positive experience that we were hoping for when we moved into our house 4 years ago. It's worth adding that it took over 2 years for us to actually have full access to our garden for the first time because of the ongoing works. And another 2 years after that for us to fully enjoy our garden because of the ongoing issues we've had to deal with in terms of waterlogging issues. Upon examining the Abbeyview site reports to discern the underlying causes of the flooding on the Abbeyview site, it became apparent, at least to us, that the initial geotechnical and drainage assessments did not sufficiently account for the site's specific groundwater conditions. According to the groundwater level investigation report, which spanned from September 2015 to January 2016, substantial groundwater level fluctuations were observed during the rainy season, notably in the lower lying areas. Furthermore, it is well established that the presence of gold clay on the Abbeyview site and the surrounding areas act as an aquitard, obstructing surface water drainage and intensifying flooding, particularly through the winter months. It is disheartening that despite this known information, Taylor Wimpey failed to implement effective mitigation measures to avoid flooding issues. It is pertinent to highlight that the flooding issues is not unique to our property. Numerous residents on the Abbeyview site have endured from similar flooding challenges for an extended period of time. There has been a comprehensive 66-page flooding report submitted by AVRA, documenting areas where flooding has been recorded by residents, which further supports the persistent nature of these issues. I include a reference to the document name in here, and I'll give you all copies afterwards. Considering the long-standing history of flooding in this area, it is imperative to implement an effective and well-maintained drainage and flood risk management system to avoid the ongoing risk of flooding issues. The proposed SUDS design of Old Park Lane development will require a robust maintenance regime to ensure the discharge orifices are regularly inspected and maintained over the lifetime of the development, as they are subject to clogging and therefore will increase the risk of flooding to Abbeyview. I therefore urge the inspector to reject this appeal until such time that appropriate measures have been taken to address the ongoing flooding concerns. Thank you.
Mr. Lisson, do you have any questions?
Only just really a question of clarification, please, Ms. Hopkins. I'm sorry that you've experienced these flooding issues. Have you contacted the council as the local lead flood authority in relation to these concerns?
I believe we have. Sherry, can you speak to that? Do you mind if my wife just comes over to a microphone? Is that okay? Yeah. Thank you.
Hello, my name is Ranjit Sarai. I'm Tertia's partner. In answer to the question, the council are aware of flooding, but in relation to our house and the complaints, we directed them back to Taylor Wimpey under the warranty of our house.
The council directed you back to, so
No, we had no need to contact the council. The flooding was in our house, in the perimeters of in the boundaries of our home. So we contacted Taylor Wimpey about those issues.
So that the council, you think, are generally aware of the issues, but you haven't contacted them as the local lead flood authority specifically about the issues you've experienced?
No, we moved into our house and we had issues with drainage, so therefore we can't contact Taylor Wimpey.
Right, okay, thank you.
Anything else, Mr. Lisson? No. Thank you very much. I don't have any questions. Mr. Green, I'm talking on behalf of you. I'm sorry. I assumed if you had, you'd be waving away at me. Oh, your representation. Thank you. So I've been handed a copy of Ms. Hopkins' representation, which I'm going to take as inquiry document number 8. Okay, thank you. So could we hear next from Joan Oldroyd, please? Thank you, Ms. Oldroyd. The usual questions, so confirmation of your name,
Yes.
whether you're representing yourself or another group, support or object to the proposed development, any qualifications you might want recording, and whether you'll be happy to answer questions.
Yeah. I'm speaking on my own behalf and I object to this application. And I'm willing to take questions.
Thank you.
All right.
When you're ready.
My name is Joan Oldroyd, and my home was built in as the very last place on the development, so I'm the last resident. And I am situated in Cascade Way, and it's the only road into the Abbey View estate, which is accessed via Crondall Lane. Crondall Lane is a very busy two-way road, particularly at rush hours. From my window, I can actually see the lines of traffic. When you leave Abbey View, you invariably have to join a queue because the queues coming down the hill, down Crondall Lane during rush hour, extends out in both directions, making it very difficult, impossible sometimes, to exit Abbey View. The junction at the bottom of Crondall Lane and into West Street, which is approximately 400 metres away, impacts the traffic flow of Crondall Lane. This queue is further impacted by 7 legal parking bays in Crondall Lane, which create a pinch point and obviously slows down the traffic considerably. Turning right at the bottom into West Street Junction, it's quite hazardous, with a substantial number of vehicles approaching town from the bypass, the main entry into town. Approximately 500 metres along West Street is the new Cox Bridge development. 300 plus, I understand it's now 320, but I can't guarantee that, have recently been granted planning permission and already has a new road access in place to begin building. The traffic implications of this will be absolutely horrendous, as no planning forecast has been undertaken to account for the additional traffic from the Cox Bridge development. This will be further exacerbated due to the proposed planned closure of Beavers Road during the school opening and closing hours, i.e. 8 to 9 and 3 to 4 in the afternoon. Traffic on the roads, particularly from north to south Farnham, use Crondall Lane as a cut-through, with peak traffic levels in excess of 600 vehicles per hour, as referenced in the Surrey County Council report dated the 2nd of August 2023. And this has already been posted on the Waverley portal. The Cascade Way common pathways are used as a safe and convenient pedestrian route to schools and to the town centre for visiting, transiting, and local residents, including a large number from the adjacent estate, the Wainfleet estate, on the south side of Crondall Lane. People need to cross the busy road, which is Crondall Lane, by utilising the adjacent pedestrian traffic lights, recently installed, I might add. Throughout the day, there is a constant stream of pedestrians. many of whom are pushing prams and wheelchairs, as well as the elderly, and they all use Abbey View as a safe access to the town. I'm deeply concerned by the prospect of an additional 400 cars from Old Park Lane site passing outside my home and the effect on my well-being and health. The effect of traffic pollution are well documented, everybody knows that, and the alarming prospect of yet more idling traffic, fumes and pollution is worrying. I moved on to Abbey View it's 3 years, nearly 4 years ago. And as usual, my solicitor exercised due diligence and nothing untoward arose from searches, not a hint of any radical change to the site infrastructure. If it had, I would have checked it out. So I moved in excited at the prospect of a new beginning, which sadly, because of this planning application, has now been blighted. The developer's sales pitch and illustrations in their brochure obviously gave no indication of what was to come. Indeed, the sales team were at pains to explain the details of the annual management maintenance fee and what we would be required to pay to maintain the facilities of the same green spaces we have now but are under threat. And we've been paying towards this, all of us, right from the beginning. With reference to the Lisle Outlet planning drawing, which includes the green village landscaped approach to Abbey View, which is a key design element in the Waverley adopted design rationale. Any changes here would fundamentally change the character of the approach and be detrimental to the character of the development that I looked forward to moving into. It's most unreasonable, very unreasonable to allow or even to consider such radical changes after such a short time. Radical changes to the life of so many people who moved into Abbey View in good faith with their children and their families. And it's really up to you, the Inspector of Planning Appeals, to stand up and defend us, please. The environment that was approved by Waverley Planning and which we all chose to invest in must be protected. Thank you.
Thank you, Mrs. Oldroyd. Mr. Lisson, do you have any questions?
No, thank you very much.
So next, could we hear from Rebecca Clear, please? And usual questions again, so name, representations of yourself or anyone else, supporting or objecting, any qualifications, and whether you're happy to answer questions, and then start when you're happy to.
My name is Rebecca Clear. I'm representing myself, very happy to take questions, and I object to the proposal. Thank you. I live at number 3, Keepsake Close. Keepsake Close was approved as a cul-de-sac, providing a quiet and safe space for residents to enjoy, with vehicular access limited to residents, visitors, and the necessary vehicles only. This was a major factor in choosing to live in Keepsake Close, as I have children and pets, and their safety and quality of life to consider. It was not designed or intended ever to be a through road, and any change concerns me greatly, as the front of my house is directly adjacent to the road. bar the footpath, and I have the safety of my family to consider. The road will be extremely close to my living room and dining room windows. This planning application changes the road status materially and proposes reducing the pavement width from 2 metres to 1.2 metres, thus reducing the safety margin, and should therefore be rejected. I'd like to refer to the Healthy Streets approach, adopted widely by designers to ensure healthy, safe, fair streets for all who use them. The 10 elements of a healthy street include, I'm sure I don't have to spell this out, people having easy places to cross, people feeling safe, having clean air, feeling relaxed, streets not being noisy, and people being able to walk and cycle. I strongly believe the proposed changes will deliver the opposite traits to our neighbourhood, notably outside my front door, where my family and pets enter and leave the house. The loss of amenity to me and my family would be extreme, and to my neighbours. On the point of parking, unloading and turning and highway safety, the transport assessment from May 23 states in sections 1 and 7 that safety and suitable vehicular access to the site can be achieved via Keepsake Close, but this is incorrect, even with the proposed road widening. The close is frequently used by residents and their children. I see it every day outside my windows as a safe area for recreational activity, which actually brings us all a lot of joy, and it's why we moved to that location. Turning it into a throughway will make these activities more dangerous and be harmful to the lives of those of us living on Keepsake Close and indeed throughout Abbey View. The planning application approved the road layouts and widths on both Cascade Way and Keepsake Close to provide vehicular access whilst also ensuring a safe environment for pedestrians, cyclists and other users. The safety and quality of life of my family will be directly implicated by the change of layout and width of Keepsake Close and its use as the sole access route. This proposal will materially change the balance of safety, as widening the roads will result in an increase to vehicle speeds, so compromising safety for all users, especially pedestrians and cyclists. As it is, the junction between Keepsake Close and Cascade Way requires careful and slow approaches from both roads to avoid collisions, which have taken place. I have seen them. The proposed widening of the roads here will create more of a safety issue, as vehicles will travel at higher speeds, and yet the alterations are insufficient to make it a safer junction. Planning for the development resulted in the redirection of a number of footpaths. Abbey View is now used for access by many non-residents. I won't repeat what my colleague said. The lack of sufficient parking for residents means many park on the curb, particularly in the close. The widening of the road will still be limited by parked cars, and indeed will place those cars nearer to the front of houses such as mine, which are directly facing the road. I've also some points to make about visual amenity and traffic generation, but I think those have been made. Noise and disturbance resulting from use. The proposals will bring more noise and pollution into Abbey View, compromise the current tranquility, and in general affect our quality of life. The proposals also make no mention of the effect of the construction traffic, so it is assumed that the developers intend for this to travel through the Abbey View site. I object to these since, as a resident of Keepsake Close, with the house where it is, the increased pollution and loss of privacy will severely and negatively impact our lives. And I too experienced this having moved in May 2020 while the site was completed. And finally, the application fails to take into account that there is a more suitable alternative access route, as mentioned, through past the UCA. That's the end of my submission. Thank you.
Thank you very much, Mrs. Clear. Mr. Litton, do you have any questions?
No, thank you very much.
Thank you. Super. So next we're going to hear from Catherine Warlow. And again, Ms. Warlow, if you could confirm your name, whether you're representing yourself or anyone else, support or object, any qualifications you want recording, and if you're happy to answer questions, and then start when you're ready to.
Thank you. It's actually Catherine Keeble. I think, yeah, there's some confusion because I use a different email address. I'm representing myself. I'm happy to take questions at the end, and I also object to this application. I'm a resident and homeowner of 14 Cascade Way, where I live with my husband and 2 children. My property is situated just at the junction of Cascade Way and Keepsake Close, which is the main junction leading into the proposed new development. Whilst when we were buying our property, I might have been a bit wary about buying a house opposite a junction. I was quite reassured that obviously the initial development plan was one of cul-de-sacs, and so therefore traffic would be quite minimal. The small and safe nature of the developments were really the reason that we chose to buy here. We were one of the very first adopters at Abbey View, so we moved in November 2019. We spent the first 18 months living on the development whilst the rest of Abbey View was being built and constructed, and it was a pretty miserable time to live there. There was a lot of construction traffic, but we lived with that, and we recognised that it was just a temporary issue. Obviously, over that time period, COVID happened, and the development and construction went on a lot longer than had been anticipated. But during that time, we lived on a really muddy development. Mud was constantly being tracked into our home on pram wheels, kids' shoes. We couldn't obviously use any of the play areas and other areas that were we were already paying a maintenance fee to maintain. And we lived with the constant noise of construction traffic. And whilst Taylor Wimpey did a good job of having a street sweeper twice daily coming up and down the roads were constantly muddy despite that. And obviously really heavy construction vehicles passing us all the time was pretty miserable. And it was also quite frightening for us because we had 2 young children at the time who would often run out ahead as traffic was passing us. But we were very pleased when that construction stopped and we could finally enjoy Abbey View development, which is a really lovely place to bring up children, and children play in the streets and in the play areas. It is a really safe place to be. And we were really sad to learn of Gleason's plans to develop and access the site via Old Park Lane, via Cascade Way. I think probably naively, I always thought that development on those fields might be a possibility, but I never ever anticipated that the development would be accessed via our own roads. And the consequences of that for construction traffic, also using those roads, those same roads for the build themselves. The need to remove the grass verges and trees, which I know others have already spoken about, trees which I and other residents have lovingly watered over the last 5 years to try and ensure their survival, finally seeing them thrive, the cherry trees that are opposite our house, the idea of those being removed and thrown out and replaced is quite upsetting, to be honest. Our house faces the junction, as I've mentioned, and like most houses in the development are all very close to the road. That's the way that they've been built to maximise profits. We endure already quite a lot of vehicle traffic and construction noise. The idea of that increasing and the issues that would create for health and safety concerns are quite concerning. My understanding is that construction vehicles would be used and would basically be involved in widening our roads and landscaping changes associated with service diversions and extension services, that these will impact everyday access for residents using their cars in Abbey View. Therefore, it is essential to have a managed traffic control system to ensure our access in and out of driveways with a well-managed and separate protected pedestrian access to Farnham and the local schools in accordance with the health and safety regulatory practice. Therefore, to ensure fully compliant procedures, an environmental impact assessment and site construction management plan should be approved to address these site works that includes work to driveways and pavements, green verges and modifications to plots 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 49, 56 and 57. There is no doubt that the entire residential development will be affected by these works due to the reductions in the road system during construction works by a single entry point to the development. Consequently, a well-managed construction plan should be made available before the access to the site is approved. No consultation has taken place, and this plan should address residents' health and safety concerns as laid down in the NPPF and the Health and Safety Executive. The Health and Safety Executive requires effective management of transport operations necessary throughout the construction process, with key issues in dealing with traffic management on site, which are keeping pedestrians and vehicles apart, minimising vehicle movements, managing the people on site, turning vehicles, visibility, signs and instructions. In conclusion, I would ask the Inspector if clause 140 of the NPPF is satisfied, as this requires a clear design to the proposed construction details. As this appeal is the principal reason for the access, these details to demonstrate the above key elements are not available for examination or comment and are essential to the execution of this working access. We would therefore respectfully request that the Inspector consider if adequate information is available to satisfy this condition, and if not, we request that you should refuse the appeal.
Thank you, Mrs. Keeble. Mr. Liston, did you have any questions?
No, thank you very much.
Thank you. Thank you. Mr. Minto. I appreciate I sound like a broken record by now, but if you could confirm your name, whether you're representing yourself or anyone else, whether you support or object, any qualifications you'd like recording, and if you're happy to answer questions, and then start when you're ready. Thank you.
So a green button. My mistake. Thank you, Madam. Julian Minto, representing myself and my wife, who is not here today. I object to the proposal, and I've got no issues with taking questions at the end, and I've got no qualifications in this regard. My name's Julian Minto, and I live at 5 Keepsake Close, which is plot 50 on the Abbey View development, which is located on the corner of Keepsake Close, which is directly adjacent and next to the proposed entrance to the new development. We have lived here since November 2020. The access route and entrance to the new proposed development will directly and significantly affect my family's quality of life. If allowed to proceed, not only will the works to create the access road have an impact, so will the next 2 to 3 years of construction traffic utilising Cascade Way and Keepsake Close. The noise, vibrations from construction, vehicles going past daily, as well as the dust and dirt from the construction site, will affect me and my wife's quality of life and our ability to work from home. We both work full-time from home. Since the completion of the development a couple of years ago, Abbey View is now an established development with all homes occupied by residents and families. Families with children and pets use the communal areas and pathways and the Abbey View access roads to play and cycle on. Residents' pets also, such as cats, wander the development access roads. Again, having the residential access roads, which are not public highways, to be used as a construction access route for a few years will have a detrimental effect on all residents' quality of life and personal safety. I work for a large company in the utility industry, and I'm involved in operations and construction projects. One of our company's biggest safety concerns that we have to manage is pedestrian and vehicle movement separation. This is managed via demarcation, physical barrier, and trained staff and contractors. Unfortunately, incidents and accidents can and do still occur, even though extensive safety controls are put in place. This is on a construction site that members of the public and young children are not able to access. Allowing this access route and development to go ahead will significantly increase the likelihood of a serious incident occurring on Abbey View. From living on other housing development sites prior to this, alternative access routes were planned to avoid the situation that is proposed for Abbey View. Major works would take place with corresponding noise, dirt and pollution caused by the construction traffic and excavations along the entire length of Cascade Way and Keepsake Close, which will limit and impact traffic flow through Abbey View. The construction traffic movements will bring safety issues to the site and will interfere with the everyday movements of residents and pedestrians in and out of their driveways. It is completely inappropriate to have a construction route going through a now established residential area for the next 2 to 3 years. When you move on to a new estate, you accept disturbance from the development being completed, but not that it will be turned back into a construction site a few years later. One of the reasons and factors as to why we chose this development to make our home was because of the protection of a strong Farnham neighbourhood plan, which gave reassurances for the people that moved into Abbey View, providing sustainability and ease of walking for many retirees and families attending local schools in the vicinity of the Abbey View development. With this proposed development not forming part of the Farnham neighbourhood plan, if this access road and development is granted, this completely undermines the purpose of having a neighbourhood plan in the first place. The Abbey View access roads were designed and constructed to meet the original design criteria. I'm not going to go into the details because they've already been covered. This design encourages slower moving vehicles through the development with just enough room to pass, with prioritisation given to pedestrian walking and social activities on the open green spaces. Again, some of my points around the number of vehicle movements to do with the original dwellings has already been covered. The proposed changes to widen Abbey View's access roads and the removal of some of the green verges has also been covered, so I will not cover that also. The ABRA committee have also made significant efforts, and that has been previously covered, so I will not repeat those points. And I've also the established trees that align Cascade Way and Keepsake Close have also been covered. However, there is one point I want to make, which is around the established trees, which lie at the end of Keepsake Close, where the proposed access to new development will be, have taken several years to establish. These will disappear to make way for the road entrance to Old Park Lane proposed development site. Also, ahead of the planning submission by the developer, the loss of 2 healthy poplar trees were conveniently removed right where the entrance will be. This was just prior to the TPO being implemented on the remainder of the trees. Major changes to the existing Abbey View development to accommodate the entrance to the new site for Keepsake Close will damage existing mature tree roots which are protected by that TPO 014/22. This area will be changed dramatically if this new entrance road is granted. Payments and changes to the footpath that this road will cross will subsequent loss of green verges and amenity space, which was a key part and requirement of the Abbey View design. In summary, to allow this proposed access road and development to proceed will have a detrimental effect on Abbey View, its residents and the local area. Furthermore, I ask that any decision considers the Healthy Streets for Surrey Design Guide, which has already been mentioned on numerous occasions, which is now being rolled out across Surrey, giving reassurances around safety and healthy lifestyle. Thanks for your consideration of my feedback. That's my statement. Thank you.
Thank you, Mr. Milton. Sorry, Mr. Minto. Mr. Liston, do you have any questions?
No, thank you very much.
No, thank you. Thank you. So then I have Mr. Tony Haslam. Thank you, Mr. Haslam. Same questions. No, you need to put it on, so it should be red if it's on. 2 little dots either side.
Right.
Okay, so
Fine.
confirm your name, whether you're representing yourself or anyone else.
Tony Haslam, representing myself, very much against the proposal. Happy to take questions and qualifications. I have 5 A-levels.
Thank you, Mr. Haslam. Ready when you are.
Taylor Wimpy claims to offer a dedicated customer service from people who rarely care We are committed to helping you find your perfect home so you can enjoy a stress-free move. Under the circumstances, this is total hypocrisy. Why? Should the plans be passed, allowing the construction traffic to use Cascade Way and Keepsake Close as the access roads to the development site, this will have, and already is having, a major effect on the mental health of the elderly and families, particularly children. We are a retired couple. I'm 77, my wife is 82. We live at the junction of Keepsake Close and Pioneer Road, where the road will be widened and the pavements reduced, as we've heard, in width, and much landscaping will be removed. Once the construction works begin, there'll be a significant increase in traffic, as we have heard, which developers estimate to be in the order of 400 vehicle movements per day. This increase in construction traffic will bring with it noise, pollution, mud in winter, dust in the summer, all of which will affect our mental health and well-being. Instead of the peace and quiet, which were the principles of the original design concept of Abbey View, we will all be subjected to living on a construction site. So much for the stress-free retirement we were much looking forward to. In the National Planning Policy Framework, it refers to promoting healthy and safe communities, and Vision for England also promotes good health and good quality of life through the effective management of noise, recognised as detrimental to health and well-being. Both seem to be completely ignored with this planning application. Many families living on the development moved to Abbey View, as we've heard, because it provided a safe environment for their children, who currently enjoy the freedom to play outside, whether it be bicycling up and down the roads, playing football, and even tennis, with the younger ones riding their scooters. For safety reasons, all this will have to stop. Many parents have reported that they will no longer allow their children to play outside once the construction traffic starts. The knock-on effect of this, they feel, is it will have an adverse effect on the mental health of their children, causing them distress, worry, and anxiety. And this was highlighted in the study following the COVID lockdowns, See Mental Health Foundation report. As a result, some families are considering moving away from Abbey View, as they are understandably concerned for the long-term welfare of their children. Should this happen, it destroys Taylor Wimpey's boast, "We are committed to helping you find your perfect home so that you can enjoy a stress-free move." Has any thought been given by Taylor Wimpey, the developers Gleesons, the inspector, and the planning commission on this issue, i.e. the mental health effect on the residents in Abbey View should Cascade Way and Keepsake Close be used as the access roads of the development site? For those of you on the committee with children, surely you can understand the genuine concerns of the parents, indeed all of us living in Abbey View. I would therefore respectfully ask the Inspector and Planning Committee to give serious consideration to the effects on the mental health and well-being of the residents when debating the planning appeal. It should not be dismissed as an irrelevance. I would further request that the Inspector and the Planning Committee dismiss this appeal on the grounds that it is unnecessary intrusion into the lifestyles of an existing community. It does not seem right to sacrifice one neighbourhood for the inclusion of another. If building more houses is deemed beneficial to Farnham, then thought should be given to finding a less intrusive route to the development site. Thank you. Any questions?
Thank you, Mr. Haslam. Mr. Lisson, do you have any
No,
questions?
thank you.
Mr. Free. I'm waiting to see if you can roll it off like Mr. Haslam did, or would you like me to repeat what I need?
No, I'm okay. Thank you. My name is Trevor Free, and I'm here to represent the AVRA, the Abbey View Residents Association, which I have their permission I will take questions, and we are objecting to this development. Now, a lot of things have already been mentioned by my fellow representatives, so I'll try to skip those as I go through. But basically, I'm here to register objections to the development of housing on the Old Park Lane site, providing it is to the benefit of Farnham and the wider community. It is to register objections primarily to the effect of these changes, which will have to the recent built Abbey View development and residential amenities in order to facilitate the construction works to Old Park Lane and to highlight the impact this will have on our residential well-being. Many of our concerns are detailed by my fellow residents in their representations, and these must be put in context with the need to safeguard our community from the loss of residential amenity brought about by the significant changes to the design of the Abbey View development, with the proposed construction works to widen the roads for the purposes of access. Working from home. Since COVID, many residents carry out their work in the peace and quiet of their home, where only the intermittent noise of a local delivery van or the neighbour's car passing their property. One may hear the chatter of children playing outside, but this is not a disturbing noise, and it is reassuring to parents that all's well. So at the present time, noise and pollution does not present any health or safety issues. Existing motor traffic movements are below 10 miles per hour due to the narrow roads, and the noise from this passing traffic is hardly discernible within the home environment. Access ways are also used by the pedestrians and cyclists in line with the policies outlined in the MPPF Section 8. Much of the existing design is included, as has already been said, in the Healthy Streets of Surrey Code of Practice. So at present, we live in a quiet, calm and peaceful environment, enjoying open windows for fresh air with little or no intrusions of loud noises or pollution to affect the healthy lifestyle of the residents. So promoting health and safe communities, Section 8 of the MPPF specifically deals with promoting health and safe communities. However, there is no doubt that our residential amenity will be subjected to significant observed adverse effects, which will be present and disruptive due to the proposed construction works adjacent to residential homes. These proposed construction works will diminish the quality of life due to the changes to the acoustic character of the area, causing residents to avoid certain activities during the periods of intrusion. They will also need to keep windows closed most of the time to avoid noise and dust pollution entering their homes. The effect of this construction work during the working day will be detrimental to their residents' health and well-being, as it will create a significant nuisance. It has already been reported that by the appellant that over 400 motor car vehicles movement through Abbey View over each 24-hour period will occur, and this has been mitigated by a bus shelter and drop pavements in Farnham. However, there is no evidence to support a significant change in the numbers. At night, the effect of additional motor car headlights in the areas where none exist at present will increase light pollution to the naturally dark landscape of the adjoining fields. Residents and local neighbour objections have been highlighted in a petition signed by over 200 residents and neighbours, plus a further 400 objections registered on the Waverley Planning Portal. In conclusion, we would respectfully ask that the inquiry takes into account the harm to the neighbourhood with the loss of residential amenity and with reference to representations of residents which have already been mentioned. The actions to prevent an increased risk of flooding to Abbey View, mentioned by Tersa, Clause 17 to the MPPF, the West Street Crondall Lane junction and traffic congestion at the exit from Abbey View, already been mentioned by Joan, construction management environmental assessments, which are the subject of further planning approvals, already mentioned by Catherine, Loss of residential amenity, clause 106 of the MPPS, which protects local green spaces, and clause 135 of the MPPF, which protects the quality of the approved space. We would therefore respectfully ask the inspector to reject this appeal in order that the appellant can seek an alternative means of access, which would not adversely affect the existing amenities, nor increase the risk of flooding to the residents of Abbey View, should the development proceed. Thank you. Any
Thank you,
questions?
Mr. Free. Mr. Liston, do you have any questions?
No, thank you, Madam.
No. Thank you. And then the final interested party that we're hearing from is Catherine Howell. And again, same preliminary points as well, please, Ms. Powell.
Thank you. I have copies of my statement. Would you like me to pass them round to save you taking notes? Probably be much easier for everyone, I feel. So my name is Councillor Catherine Powell. I am the County Councillor for Farnham North. I am a chartered chemical engineer and a fellow of the Institute of Chemical Engineers, and I have more than 30 years experience designing flow systems. And I am very happy to take questions, and I do object to this application, appeal, apologies. Thank you for the opportunity to address this inquiry. I've already advised I'm a fellow of the Institute of Chemical Engineers, a Surrey County Councillor for Farnham North, and as a Surrey County Councillor, I will start with transport impacts. As you will have seen from my detailed representation on the existing traffic situation based on actual fixed point traffic monitoring from June 2024, the traffic levels already exceed the values projected by the appellant's consultant in 2028. This is not addressed in his proof of evidence. Why? Why has the draft highway statement of common ground been accepted? It's not been sent to the Transport Planning Development team at Surrey County Council. The Surrey officer named hadn't seen it until I sent it to him last week, and neither has the current officer responsible for the site. Why? Probably because they don't agree with a word of it. They reviewed the application and objected. Then the Waverley Borough Council planning officers nevertheless recommended granting permission in December 2023. The Surrey Highways officers then had only a few days, not weeks or months normally required, to work on possible mitigation measures. While the appellant agreed to those proposed measures, they refused to provide evidence that they would work as mitigations. As I said in my representation, the only effective mitigation we know will work is a western bypass. The draft statement of common grounds that no one in Surrey had seen until last week ignores the challenges raised by the Surrey officers, doesn't mention my evidence, and ignores the need for a western bypass. Please do review my thorough analysis provided in Appendix 1 of my representation. This appeal development is contrary to the NPPF in paragraphs 115D, 116, and the Farnham Neighbourhood Plan 30G. What about flood risk? I have carefully reviewed the appellant's flood risk assessment, and my detailed analysis is provided in Appendix 2 of my representation, which I hope you will consider. Others who live on the Abbey View estate have already talked about the ongoing flooding issues of their estate downhill. I will focus on two reasons that, based on the appellant's flood risk assessment and the SUDS design, this appeal should be dismissed. The geology of this site is complex. It includes a fault line. The appellant provided no map showing this fault line across the proposed site layout. I created and included one in my representation. The fault line is under homes, attenuation ponds, significant reprofiling, and large underground suds tanks. The appellant acknowledged that the fault line requires additional testing and slope stability analysis. I firmly believe that it will impact on the layout, which will increase the already significant visual impact on St Andrew's Church in particular, and be in breach of RE1 and RE3. As an absolute minimum, there should be a pre-commencement condition, as at the moment there is nothing. The second reason is the flow restriction, called orifices, required to reduce the surface water flow from the site during a storm to an acceptable level. As a chemical engineer, I have serious concerns about this. I agree with part of the appellant's own risk assessment, which states restrictions below 50 millimetres or 2-inch are prone to blockage. Since the SUDS guidance does not include a minimum orifice size, a glaring gap, the local lead flood authority can only advise that the design meets the guidance. They cannot object. They know, the appellant knows, I know, I think anyone would know, it is not possible to stop 10 millimetres, less than half an inch, that's the size of a 5p piece, from blocking. Condition for robust maintenance is simply not enforceable. It is contrary to paragraph 57 and is in conflict with paragraph 178B of the NPPF. There are other reasons this appeal should be dismissed, and I will cover 3 more: infrastructure, SANG, and housing mix. Wavy assessed the infrastructure required in Farnham based on the projected housing in the Farnham Neighbourhood Plan up to 2032. The Farnham Neighbourhood Plan is delivering, but sadly, the infrastructure isn't keeping pace, mostly due to the lack of available land and SIL funds being insufficient to cover the true costs. Infrastructure limitations in Farnham make this application counter to the NPPF December 2024. For example, the development is contrary to paragraph 100. There is an ongoing lack of secondary school places in Farnham. Was 3 forms, now 4 forms, 120 places in every year. Currently, no strategy exists to resolve this. No site is available for a new school, no feasibility study to expand existing schools, no easy task as the nearest school is Weydon. Already 11 form entry, 330 pupils in every year, the largest in Surrey. Farnham is right on the edge of Waverley and Surrey, and there have been and continue to be very large housing developments in the immediate area of Farnham, further straining infrastructure. Housing development is driven by 5 different planning authorities. My representation provides maps of the surrounding development indicating the cumulative impact. Ongoing unplanned development makes a mockery of a plan-led system associated with neighbourhood and local plans, as there is no consideration or mitigation of the cumulative impacts. SANG is another critical issue for development in Farnham. Farnham has run out of SANG and doesn't have enough for the remaining brownfield developments in the Farnham Neighbourhood Plan. The proposed SANG associated with this development is not consistent with policy FMP 12, which states that SANG should be readily accessible from and well connected to the development it serves including by sustainable modes of transport, so it is able to divert or intercept trips from the proposed housing development to the Thames Basin Heath Spa. The proposed SANG is in Church Crookham, which is not readily accessible by sustainable transport, as there is no bus, no safe cycling route, nor is it well connected. It is 6 kilometres away. To access the proposed SANG, any future resident of Old Park Lane development would need to travel past both the Farnham Park SANG and the spa, so it is unlikely to divert or intercept trips. The ecology proof of evidence for this appeal clearly states that the survey they have undertaken shows regular usage by dog walkers across all days, demonstrating its suitability as an alternative SANG. Given Farnham's lack of available SANG, this meets the requirements of FNP 12, and the allocation of this site as SANG would be much more appropriate than further housing. Farnham needs social rent, as acknowledged by the Waverley Affordable Housing Delivery Strategy 22 to 25, in line with paragraphs 33, 34, and 63, 64, and 66 of the NPPF. Despite this, a site outside the Farnham Neighbourhood Plan is 27% affordable housing. The appellant hasn't even provided the minimum amount required by Waverley Local Plan Policy AHN1, which is 30%. Given the lack of land that is available in Farnham in areas without flood risk or transportation network constraints, a commuted sum is simply not acceptable. Any site outside the Farnham Neighbourhood Plan needs to prioritise social housing. Not meeting even the minimum requirement is completely unacceptable. In summary, there are fundamental flaws in these proposals for a site that is outside the Farnham Neighbourhood Plan, which currently carries full weight as it is less than 5 years old and is delivering with that plan. The Waverley Infrastructure Delivery Plan has not delivered in Farnham because of the lack of available sites. This site should be used for SANG, not more housing, and would allow the brownfield developments in the town to be supported in line with the NPPF. Many of the roads in Farnham are at capacity. There is no evidence that the proposed mitigations as part of this development will actually work. There is plenty of evidence that the impact has been underestimated. There is an identified fault line across this site that has not been investigated, acknowledged risks of slope stability, and no condition to address the associated risks and the likely impacts on the layout, and therefore further increase in the impact on the intrinsic character and beauty of the countryside. The SUD system is not maintainable and creates a flood risk to everything downhill, which will be additive to the issues that already exist on the Abbey View estate. Please take the time to read my representation and dismiss this appeal. Thank you, ma'am.
Thank you, Councillor Powell. And I've marked Councillor Powell's representation as inquiry document 9. Mr. Lisson, do you have any questions?
Yes. Sorry, I may have missed it, Councillor, but are you here representing yourself or in the capacity as a Surrey County Councillor?
I'm here as a Surrey County Councillor.
Representing the council?
No, representing my residents as their elected representative.
Sorry. Are you appearing in your position as a councillor representing Surrey County Council, or are you representing yourself?
Perhaps the inspector can help me with that question. I'm not sure I understand it.
No, that's fine. I think what Mr. Liston's trying to ask, correct me if I'm wrong, is have you agreed with Surrey County Council that you're going to come on behalf of Surrey County Council to make a formal objection to this scheme on behalf of Surrey County Council? So has that discussion taken place, or are you doing this in terms of yourself and your own concerns in terms of your own professional concerns that you've flagged up?
So in terms of the fact that have I spoken to the TPD team about the fact that they have not had follow-up in the way that was implied by Mr. Litton earlier regarding the highway statement of common grounds, that is an agreed position. They have not had those discussions. In terms of the flood risk, that is my professional opinion based on my expertise as a chemical engineer, which is not the same as the expertise that the team would have as the lead flood authority. So I guess I'm here as an individual in that sense, ma'am.
Thank you. Mr. Liston, does that assist you or not?
Thank you. And I'm just going to ask you some questions about this. Do you hold a particular portfolio at Surrey County Council?
No, sir, I am the leader of the opposition.
Do you know Mr. Lahan, James Lahan?
I do, sir.
Well, the Statement of Common Ground was sent to Mr. Lahan back in December, and my instructions are, and I'm sure Mr. Bell, when he comes to give his evidence, will confirm this, that I think a total of 4 chases were sent to Surrey County Council in relation to the Statement of Common Ground, the latest being on the 6th of January of this year, and no response has been received. Was it Mr. Lahan that you spoke to who said that he had never received it?
The communication from Mr. Lahan was he had received an initial communication in December to which he had responded he was no longer the case officer. I have spoken to the current case officer and he has confirmed he has had no correspondence despite his name having been given to the appellant.
And who is that case officer, please?
Richard Cooper.
Now, you say that you drew their attention to the document. Did you ask them perhaps to respond to the appellant?
I have been extraordinarily busy because of the local government reorganisation stuff going on. I sent it to them on Thursday. I believe they attempted to reach out to Waverley Borough Council on Friday.
Very simple question, Councillor. Did you ask Mr. Lahan or Mr. Cooper or anyone else to respond to the Statement of Common Ground to the appellant when you drew it to their attention? That's a yes or no.
I didn't know I was supposed to, so I identified it to Waverley, sir.
That's a no then. You did not draw it to, you did not suggest to any Surrey County Highways officer that they should respond to the Statement of Common Ground that had been sent to them weeks ago.
My understanding is they had responded and told you had approached the wrong officer, and my approaches to both those officers are that there's been no further discussion, sir. I don't view it as my responsibility to follow up on the appellant's behalf, sir.
In relation to the flooding issues that you have raised, have you drawn your concerns to the local lead flood authority?
I have raised questions to both the local lead flood authority and the planning authority, and both have advised the guidance does not provide a minimum orifice size, and therefore they are unable to object on that basis.
And is there anything in writing to that effect, please?
There are questions that have gone into both councils, which are in writing and in the public domain, sir.
Can we be, if you have raised these individually and you have had a written response, can we see those, please?
You can look at the planning committee minutes, sir.
I've looked at the planning committee minutes. I'm asking you a very specific question, Councillor. Have you contacted the relevant officers at the local lead flood authority, and have you had a written response to your concerns from them?
Yes, sir.
Can I see those documents, please?
I can arrange to send those to the planning inspector if it's necessary, sir.
Well,
Yes.
and I would like to see those, please.
I think if they're available, then it's a case of submitting them to the appellant and the council so that everybody can see them.
No further questions. Thank you.
Sorry, Inspector, just a point of clarification. Should I send that through to the planning inspector? I don't have details of how to contact the appellant.
No, it's fine, Councillor Powell. If you send them to the council and the appellant, or to the council and the council will forward them.
Okay, thank you, ma'am.
Thank you. Mr. Green, did you have any questions? No. No. Councillor Powell, I don't have any questions. Thank you for your time. Right, that finishes the list of people that wanted to make representations. Mr. Edge, was it Mr. Edge? Apologies, it doesn't finish the people that would like to make representations. Mr. Edge, would you like to make your way down? Oh, thank you. And do you have one for the appellant and the council, Mr. Edge? Do you have a copy for the appellant and the council? Oh, okay. Is it possible to make a copy? Thank you. Mr. Edge, so again, same things, confirmation of name, representation, supporting or objecting, and whether you're happy to answer any questions, any qualifications you'd like recording if you have them.
Oh, right, okay. Stuart Edge, speaking on behalf of myself, speaking against the appeal, and I'm happy to take questions. I live on Beavers Road, which is near but not in the Abbey View development, just as a comment. I put in a written representation, made 2 points. The first one has been covered by others, so I shan't repeat it. The second point relates to the principle under which the application is being considered at all as an allowable development, that building in the Waverley Council area is not keeping up with the local plan. And as a result, sites outside of the local plan can be considered for development. Some years ago, I was a councillor and chairman of the local planning committee, so I do understand the rules and that they apply here. Although I would admit that some of the detailed arguments which have been raised by the appellant are new to me. However, I would like to point out that my understanding of the reason that Waverley is not kept up with the plan is not because they have failed to give enough planning permissions. They have. It is because developers over which they have no control have failed to build. 2 cases need mentioning. Firstly, the largest 1,800 houses at Dunsfold is the main reason for Waverley's shortfall. And secondly, and locally most annoying to local people, is the site right in the middle of Farnham that's been derelict for over 5 years. Because it is demolished, it is counted as started, and as a result, the planning permission remains valid indefinitely. Waverley cannot force building on these sites, and yet developers can use the situation to force development elsewhere outside the agreed plan area. I mention this not to argue that the rules do not apply in this case. I mention it to ask that when you, the inspector, balance rules and facts that pull towards allowing or not allowing the appeal, that you take this situation into account to weigh the scales towards not allowing the appeal. Thank you.
Thank you, Mr. Edge. Sorry for nearly forgetting you. Right. So that's, do you have any questions, Mr. Litton?
No, thank you.
No. Mr. Green?
No, madam.
No. Right. That
Thank you.
concludes hearing from interested parties. We had intended, according to the timetable, to also do highways evidence prior to lunch via a roundtable session, but it is now 1:10. I'm happy to be guided as to whether or not we crack on. I think possibly a lunch break would actually be beneficial, and to do the session when we return. Was everybody happy with that?
Yeah. Yes.
Listen, yeah, super. In terms of lunch-wise, we are obviously right next to a Waitrose, so you don't have far to go for lunch. However, again, I'd normally say an hour, but I'm happy to reduce that to sort of 50 minutes and return at 2. Again, if people are happy, then we can crack on. Yep.
Yes, ma'am.
Yes, splendid. Thank you. So I don't have any issues to raise other than an update on the section 106 is required at some point. Checking the conditions to make sure that there was the final reason for that. And I think the parties agreeing the housing delivery figure for Farnham, but that can be dealt with at any point in the next few days. So
Copy of Mr. Bridges.
excellent, I will accept that. And that will be inquiry document number 10. And if no one has anything procedure-wise to raise with me, we will adjourn and we will reconvene at 2 p.m. Thank you.
Testing. 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 Test. 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 Testing. Test. Test. Test.
This one works.
Testing.
Maybe doesn't.
Oh, testing. Oh, it's because that's quite far back. Testing. Sounds loud and clear to me.
Okay, let's use both and see.
This one is working,
This
but
one.
the problem
Yep,
is
this is one.
the problem with this. The problem with this one is that the wire's short,
You have to lean in.
and so yeah, you've got to be here.
Tasting.
Testing, testing. It's a little bit longer.
Tasting. Yep.
just need to lean into this one.
Yeah. I think so.
Hello, 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 hello.
Mm-hmm. You can hear it there. Is it?
wire's quite short, so it is working. But if you sit back here and speak into it, it's not picking it up. And I can't pull it forward on the desk because it's really tight on the wiring. But it is working if I lean in.
Yeah. Mm-hmm. So it's an outside company that comes to do this. Okay. Do you know what company that is? Sound Advice. Okay. Good to know. So would they come and fix any of these that are? Sound Advice.
And who would contact? I mean, would it go through IT or you guys or us?
And they do with that computer. I don't know how much they cost.
So if it were the case, we would write to you to ask you.
And then we'd call them.
Okay, great. But I think the wiring is our IT.
Why, yes.
Yeah, I would think the cords are our IT.
Yeah.
So I can log a ticket for them to just come and put it, well, they can go in there and put a longer cord in so that we don't have this issue going forward. I think. Yeah, I can say that round table, the one microphone's cord is very short. We need to have a longer cord if they can, then it will be not a problem. Do you think that, yeah, oh.
Hello?
There you go.
Hello, hello, hello.
There you go.
1, 2, 3.
Oh, there you go. Let's leave these two.
But this one.
Right, good afternoon, everybody. It's 2 o'clock and the inquiry is now reconvened. We are moving on to have a roundtable discussion about highways evidence. Again, as I said before the adjournment, this is not in dispute between the parties. However, there are a number of representations on it and I have a few questions. So I'm grateful to you, Mr. Bell, for your proof of evidence. Thank you. I'm going to start with my own questions and then I will invite interested parties that may have some questions if they'd like to do so through me, then that's absolutely fine. And if the advocates have any questions, then happy for you to take that through me as well. Mr. Lisson, you look desperate to say something.
I'm trying to clearly do too many things at the same time, right? But start.
Did you want to say something or are you just, right, okay.
What I was going to suggest is I'll introduce Mr. Bell, so everyone knows exactly who he is and what his qualifications are. There was one matter I wanted to pick up with him arising from Councillor Powell's evidence about what she says we hadn't done in relation to the statement of common ground, which I just want Mr. Bell to clarify.
That's fine. That's fine because I had some questions on that. So it may be that you cover off the questions that I had anyway. And it probably would be helpful for you to introduce him as well. So if you'd like to do that, and then I will continue with my questions.
Thank you very much, madam. So your proof of evidence, Mr. Bell, which for those who have got electronic copies is CD 9.3. You have an introductory section, and by reference to that, you are Philip Bell. You have a first-class Bachelor of Engineering degree in Civil Engineering, the Royal Society for the Prevention of Accidents accreditation in Advanced Road Safety Engineering. You're a chartered member of the Chartered Institution of Highways and Transportation and a member of the Institute of Logistics and Transport, and you have over 35 years experience in the field of transportation, planning, traffic engineering and highway safety. You explain a little bit more about the experience and that you have in relation to highways and transport planning. And then you set out the scope of your evidence, and then having set out that scope of evidence, you address each of those particular matters, all taking that as read. I would just please like to ask you, though, about the evidence that Councillor Powell, Councillor from Surrey County Council, gave this morning about the statement of common ground. First of all, did you prepare the statement of common ground?
I did, alongside a colleague, yes.
Yeah. When did you and who did you send that document to?
It's Surrey County Council claim it's their policy not to enter into statements of common ground unless requested by the inspector, madam. So that was requested during the case management conference on the 9th of December, which it's noteworthy that CMC was also attended by James Lahan, whose name was mentioned earlier. You, madam, set a deadline for that document of the 7th of January. We prepared the statement of common ground. We sent it to James Lahan at Surrey County Council on the 12th of December, some 3 days after it was requested. We chased on the 13th, 17th and 19th of December by email, either from myself or a colleague, and directly to James Lahan. And then finally on the 6th of January, the day before your deadline, madam, on none of those occasions did we receive a bounce back. On none of those occasions did we receive any response whatsoever from James Lahan saying anything at all, let alone that he was no longer the case officer. We hear from, excuse me, from Councillor Powell that the case officer is now Richard Cooper. Funnily enough, Richard Cooper is in this building attending a hearing. I've tried to speak to him, but they haven't had a break as far as I can tell. So I haven't been able to do so. I did, however, have a meeting with Richard Cooper yesterday, as recently as yesterday, and he mentioned nothing about this. No, in relation, sorry, thank you in relation to a completely different matter, but I would have thought he might have raised it if if he thought he was meant to be doing something that I was chasing his colleague for. So that's all I can say, Madam, on the matter. Really, we did our best to get Surrey County Council to enter into that statement of common ground. As you know, there's no objection, so there shouldn't be anything controversial about that statement of common ground, but nevertheless, they haven't engaged.
Thank you, Mr. Bell.
Thank you, Mr. Bell. Those were the only questions, sorry.
Thank you. Mr. Green, was there anything you wanted to say at this stage?
Madam, I do have one matter of clarification. I'm happy to go at the end or now.
No, happy for you to take it now.
Thank you very much. Mr. Bell, the transport assessment, CD 2.1, do you have access to that?
I do.
That's the document that sets out the likely trip generation arising from the proposed development.
That's correct.
And we have that, I think it's page 18, digital page 21.
Yep.
And you have a table there, helpfully, table 5.1.
Yep.
And I can see the data there. It's all pretty clear.
Okay.
I couldn't match the information there with the information given on trip generation in the noise assessment that Mr. Packer produces as an appendix. I just want to know whether you can say that different information was given for the benefit of the noise assessment or the same information.
I gave figures to Mr. Packer. I can't recall exactly at which point we were taking traffic flows. So the figures in table 5.1 are estimates of the number of traffic movements likely to be generated by the developments. So it may be that if we were looking, if Mr. Packer was looking at noise further, if you like, downstream, then there may have been additional dwellings and therefore the numbers may have been higher. Just to clarify that point, if you draw a line across the point, the transition between existing Abbey View Taylor Wimpey scheme and the proposed scheme, these are the additional numbers that would cross that line. But if you went right back to the end of Cascade Way, Condell Lane Junction, for instance, the flows would be higher at that point.
I appreciate that. I absolutely, that's very clear. It's just that the traffic flows in the noise assessment appear to be lower rather than higher.
Right.
Obviously, you're not responsible for the noise assessment, so I can't ask you about that. But I just wanted to raise it because and it is a point of clarification. I just don't understand why we have different figures. That's all.
Okay. I can't deal with that right now, but I can speak to Mr. Packer
if you
after
could.
this, and perhaps he could clarify.
That's very helpful. Thank you very much. That's all I have.
Thank you, Mr. Green. Okay. Mr. Bell, I just had a few questions for you, not a huge deal, and then I will, like I say, ask if any interested parties would like to make any questions. Can I just clarify one point in terms of the statement of common ground for the highways? Whilst you sent one to Surrey, I just want to make the point, and you can answer the question, was a statement of common ground in respect of highways submitted to PINS?
I believe through the planning consultant Turleys.
For highways?
Yes, that draft.
The draft, but only a draft was submitted to PINS.
Yes,
there's no agreed statement of common ground at all.
No,
there?
Correct, because Surrey County Council did not engage with us.
Right. So can you just elaborate with me a bit as to, so Surrey County Council said that Old Park Lane was not suitable as a construction access for construction vehicles. And some discussion was raised earlier from interested parties about using the access from the university. Could you talk me through why those options were discounted as to why they're not deemed suitable?
Okay. I've been involved in this project for about 6 years. The original proposals were for a larger quantum of development. This is set out in my proof, Madam. 150 units for which all access was intended to be via Old Park Lane. We moved on from that over a period of time mainly for planning related reasons, due to the landscape impact that a road a permanent road would have had. It was always my professional opinion that construction access via Old Park Lane would be preferable, given the nature of Old Park Lane and the number of dwellings that would have been affected. And we did some work to demonstrate why we consider that would be acceptable. It is relatively narrow, but it is wide enough in places for two construction vehicles to pass. However, Surrey County Council took the view that construction access should not be permitted from Old Park Lane and recommended a condition in that regard. I should add, I don't see any issues, safety or otherwise, in relation to construction access via Condell Lane and Keepsake Close. You know, my view is that there are two reasonable options there, and we should be considering both as part of the construction management plan. However, that's not what Surrey County Council wanted.
And representations were made by interested parties earlier about accessing through the university. Are you able to elaborate as to why that wouldn't be an option, or why you feel that wouldn't be an option?
It's a private road through private land. I'm not aware that any discussions have taken place with the landowner in relation to that being used for construction access to the site, nor do I consider that necessary given the other two options that are available.
Thank you. So in respect of Keepsake Close and Cascade Way, there's no signage in relation to speed restrictions or anything there, are there?
I'm afraid I can't recall. I mean, they're private roads.
Yeah.
So not subject to the
I
same.
didn't see any on my visit.
No.
And so in terms of maintaining low vehicle speeds, and I'm not a transport expert, and I'm perfectly happy to admit that to the room. I don't need to be because I've got one here. But in terms of regulating speed and driving behaviour and movement, how does that work in your opinion? How does that work within that area at the moment in terms of what factors affect it to keep those speeds down?
Two points to make there. Firstly, there are, I believe, 6, maybe 7 speed humps as existing on the section of road between Condell Lane and the site, the development site. And those, Madam, and you'll no doubt drive this yourself, assuming you drive, they do have the effect of significantly slowing speeds to, I say, below 20 miles an hour. The second point is, you've heard earlier about concerns that increasing the width of the carriageway will lead to increased traffic speeds. I should just point out just the background to that increase in width. There are 2 widths that I talk about a lot in my world. One is 4.8 metres, one is 5.5 metres. 4.8 metres is the generally accepted minimum width for a car to pass an HGV, and these roads in question are currently 4.8 metres wide. 5.5 metres is the generally accepted minimum width for an HGV to pass an HGV. And as the number of units increases, the likelihood of 2 HGVs meeting increases. And that's not, you know, it's not going to be 2 refuse vehicles meeting, but it could be a refuse vehicle meeting a construction vehicle associated with someone's extension, for instance. But I don't accept that widening the road to 5.5 metres will have any material effect on traffic speeds. And the reason I say that is, firstly, the width would only influence traffic speeds in the event of cars coming the other way. But when there's only one car travelling in one direction, the width has no impact on vehicle speeds. And these are quiet, very lightly trafficked residential streets. And the second point is that the speed humps are there in any event, and it's those that reduce and control the traffic speeds. It's not uncommon for private roads to not have speed limit signs because, of course, you know, it's difficult to enforce. Hence why I assume, and I wasn't involved in the original ABV scheme, but hence why I assume that the speed humps were put in the first place.
Thank you. In respect of the visitor bays that are to be removed and the concerns were raised earlier as well by interested parties about the reduction in width of the pavement and the issue that that might have on parking. When I visited the site yesterday, I didn't park in a visitor bay because it said quite clearly that they were for residents. And I didn't want to sort of stop and then have to have polite conversation with anyone. So I did park up on the curb, and I noticed that there were other vehicles parked on the curb as well. And this was at about 2 o'clock yesterday afternoon. And I just appreciate your view on whether or not you feel that reduction of those curbs will have an impact in terms of additional stress for people parking on the curbs and the impact that might have on the safety of the pedestrians. I mean, we heard lots this morning about children playing and it being a pedestrian thoroughfare down into Farnham, and the effect that you feel that that might have in terms of safety from a traffic perspective and from that possible point of conflict between those two users.
Sure. I can't comment necessarily on why people are bumping up on curbs, but I assume it's because the road is narrow. By widening the road, I would have thought we reduce the propensity for people to bump up on the curb. So just to recap, you know, at 4.8 metres wide, a car should be able to park without bumping up on the footway, and an HGV and all other vehicles should be able to pass. But, you know, it would be relatively tight. And that could be why people are bumping up on curbs. If we widen the road throughout to 5.5 metres, which we are, that provides an additional 700, which is, you know, 2 and a bit rulers, you know, to help give context. That would, I would say, reduce the likelihood of people bumping up on curbs. Yeah, theoretically, they would still be parking in the same place in proximity to an adjacent house, but instead of bumping up on the footway and blocking the footway, they wouldn't be, assuming we're widening on that side. And there is one location where we're widening into a footway, but replacing the footway on the other side of the carriageway. And just on that note, I've talked about the widths and why we're doing that, but also the proposals are also intended to provide a continuous 2 metre footway all the way into the development site, where there is not one at the present. That's why we're sort of juggling around with visitor bays. We're not removing any visitor bays, we're relocating them.
Thank you. And then just finally, there's some toing and froing in terms of the reference to the in the traffic. I'm just trying to look 4.15 of your proof.
Of my proof?
Of your proof, yeah. In relation to the traffic impact on local roads.
Yeah.
And there was some toing and throwing about the figure of 0.88. And how that being sort of above 0.85, which therefore takes it out of free-flowing traffic and
Correct.
this stress point. Could you just clarify that for me? I note what you say in your proof, but it would be helpful to just make another note of it.
Understood.
And also, if you can just confirm one way or another, if that was for a 15-minute period, is it always the worst case scenario that you sort of take in this? So if that was anywhere else within the findings as well, that would flag up as well.
Yeah. So dealing with the last point first, Piccadilly, which is the piece of software in question here, which simulates priority junctions, or T junctions as they're often known, it is the piece of software used, and it's the correct approach is to model each 15-minute period, and that involves inputting traffic data individually for each of those 15-minute periods, and that's the approach that we took. We report findings based on the worst case, and in this case, there was one of the 4 15-minute periods where the RFC exceeded 0.85, and that's just on one movement on one arm of that junction during one of the 15-minute periods, and it's the right turn out onto West Street, predictably, perhaps. Surrey County Council took issue with that, to my professional surprise, I have to say. And I'm sure you've heard this before, Madam, but for the benefit of everybody else, you're right that 0.45 is traditionally considered to be when free flow conditions occur. The theoretical capacity, or the RSC, the acronym stands for ratio of flow to capacity. So if the flow is 100 and the capacity is 100, you get an RFC of 1. And that is the theoretical capacity of that arm of that junction is 1, not 0.85. So it's very unusual. And I would go further to say unheard of in this day and age for somebody to take issue with a 0.88 RFC just during one 15-minute period.
Just for my understanding of the crash map data, do these include pedestrian crashes as well? They do, don't they? Because I think the only ones that are in there were vehicular ones.
Yes,
is that right?
This is any injury accident that's reported to the police.
Okay.
So that would include a cyclist striking a pedestrian, for instance, if it were reported and if injuries occurred.
And then could you just talk me through how you would envisage a construction management plan working? And we heard again an interested party flag this up. I think it might be Mr. Milton, who talked about he works in the construction industry, and again that having to divide pedestrians and other types of travel from traffic. And like I said, I drove around the site. Yes, not the site. Drove around Keepsake Close and Cascade Way yesterday. Can you talk me through how you would envisage a construction management plan working in terms of, again, avoiding those conflict points between children out, people using those walkways through to Farnham, and some of those HGVs that would be moving backwards and forwards within those roads as well?
Sure. The first thing I would say is that there is a sort of common perception, I suppose, that all construction vehicles are large, big, ugly lorries. That's not true. In fact, the vast majority of construction vehicles are vans, work people's vans. It's the first thing I would say, and in my proof, I've sought to hazard a guess at the realistic number of sort of larger construction vehicles. Even then, you know, the vast majority of those vehicles will be smaller than a refuse vehicle, and these roads are, of course, designed to accommodate refuse vehicles. In terms of how the construction management plan will work, I mean, we get involved in them, but we'd expect a contractor to be involved alongside, so on and so forth. But you know, fundamentally, the construction management plan will deal with sizes, timing of vehicles. So vehicles can be timed outside of key periods when children are going to school, for instance, and that would be quite common in relation to something like this. The construction, there was concerns expressed earlier about mud on the roads. You know, we've heard that there's possible drainage issues, mud, and so on and so forth. And I've certainly seen that myself. So you know, that would inevitably lead to wheel washing facilities on the entry and exit to the site. To avoid that, I think banksman is something that can, you know, so staff can be positioned throughout the scheme, so throughout, Abbey View. So you could use 1 or 2 banksmen just to help to coordinate traffic and help to manage pedestrians as necessary. I think it's you know, the construction vehicles and their drivers travel long distances to get to these sites, so it shouldn't be assumed that once they're within a residential area that they cause a hazard. You know, same as the refuse vehicle driver doesn't default to being a hazard. But there are ways that those drivers and vehicles can be managed by putting personnel on the ground. It's expensive, but it can be done, and it is done, particularly in London, for instance.
Thank you, Mr. Bell. I don't have any further questions myself in terms of your evidence. I don't know if Mr. Lisson or Mr. Green have any additional questions at this stage.
No. Thank you, Madam.
No. In which case, I'm going to see if there are any interested parties that would like to ask questions of you. You may find it helpful to move around slightly so that you aren't talking.
Depends where. Yes, exactly.
It is a bit difficult, isn't it, as to where questions come from. Mr. Edward.
Yeah. Okay.
That's right. Perhaps if you sit with your back to Mr. Green, I'm sure he won't be offended.
Okay.
Thank you, Mr. Bell. Councillor Powell, your hand was up.
Thank you, ma'am. Mr. Bell, is it common for planning officers to recommend approval when a county highway authority has objected?
No, but in this case, whilst the county highway authority did object initially, ultimately they had no objection.
You are aware that the objection was in place at the time the officer's report was issued, and it did record an objection in December 2023, are you not?
That chronology sounds right, but subsequently to that, they reported no objection.
And the no objection was based on the fact that in the intervening period, they had been forced to identify mitigation measures that you subsequently decided that you would accept. Is that true, sir?
Sorry, they were forced by who?
So if the planning authority had deemed that they were going to recommend to grant against the the highways authority recommendation to object, at that point, of course, the highway authority has to come up with any mitigation measures they may think may help. Do they not?
We came up with the mitigation measures in actual fact, but in answer to my question, you're saying they were forced by the planning authority.
I'm sorry, I'm struggling to see you and make eye contact with you. Would you mind terribly moving? Thank you. Thank you very much. So in terms of those mitigation measures, did you undertake an assessment of those mitigation measures to see if they generated the mitigation that was necessary?
When you say generated the mitigation, I don't fully understand the question, but I think the question you're trying to ask is, did we undertake an assessment to see if those measures proposed would lead to the modal shift necessary to reduce the RFC discussed just now from 0.88 to 0.85, which I believe Surrey County Council would have deemed to be acceptable. Is that the question?
Did you undertake the measure? Yes. Did you assess the effectiveness of the mitigations based on the projections?
No, I didn't, because I consider it an unreasonable request of Surrey County Council, as I believe I've put in my proof, given that the RFC was only 0.88 for one 15-minute period.
And have
I do not consider that constitutes a severe impact. Far from it, in fact.
Have you seen the representation that I submitted in Appendix 1?
I haven't, no.
So are you aware of the fact that the traffic measured in June 2024 is higher than the projection you made in 2028 on Crondall Lane?
I heard you say it earlier. Where was it measured and how?
It's a fixed monitoring point that's installed by Surrey County Council across the whole of Farnham. We obviously have a major infrastructure project going on in Farnham, so those fixed monitoring points around the town, as is stated in my representation.
Okay, well, traffic flows tend to fluctuate by 10% on a daily basis, so I'm not surprised if there was one snapshot that it was higher. Not in the slightest bit surprised by that. You know, traffic growth nowadays is lower than it has historically been due to post-COVID changes in working habits and so on and so forth. So we're not anticipating a big increase anyway from now to 2028, which is the period that we modelled. So I'm not surprised by that, taking one snapshot versus one other snapshot. No.
So it's a fixed monitoring point. It's 24 hours a day, 7 days a week, 365 days a year. I just happened to use the data from June, and you used a single monitoring data point in July 2020, I believe.
I'm not sure it was July, September 2020. September 2022 is when we got our obtained our traffic data. It's normal to take traffic survey data for a single day. Was agreed with Surrey County Council during pre-application discussions.
And do you accept that the NPPF states that you have to look at foreseeable future conditions as well as current conditions when you're looking at highways?
What do you mean by foreseeable future conditions?
I believe that's the wording in the NPPF. I can't remember the exact wording.
Not familiar with
Somebody
that
has it
wording
to
from
hand.
the NPPF.
I can read it to you.
But we have to, we do have to take account of committed development, and we do that by applying tempo growth, which we've done in this case.
So let me just find the number for you. I'm sure that will help. Oops. But fundamentally, you haven't looked at the data that was presented in the attachment that I generated, and you haven't looked at the increase in traffic or the other increases in traffic that are predicted as part of the infrastructure programme.
I haven't looked at your document, as I said, I'm afraid.
Would you accept that if the traffic levels were higher on that road now than you had monitored in 2022 and were higher today than you had projected them to be in 2028, that junction would be placed under strain?
On what road?
Crondall Lane joining onto West Street.
I think if peak hour traffic flows were materially higher, it would affect the output of the junction modelling, but it was also depend on the flows on West Street. So I don't think you can cherry pick, you know, without your own modelling. I think it's difficult for you to robustly challenge mine by picking what traffic flows on one road.
And the road, okay. You are aware of the fact that the Coxbridge development is on West Street, so that will also obviously impact on traffic flows that are not included in your model.
It was alleged earlier that there was no traffic assessment for that, which I find very surprising, but anyway.
Well, there's no traffic assessment for that in your modelling, so.
No, I thought it was alleged that there was no traffic assessment submitted with that approved scheme.
That approved scheme was approved some number of years ago, sir, and is not included in your application.
It is by virtue of the tempo growth. We've applied tempo growth to our baseline traffic flows, and tempo should take account of committed developments such as that.
Yes, and oh, of course, you haven't read the representation I sent. So the tempo model only shows 4% growth over a 6-year period,
Correct.
and we've had more than that over a 3-year period. Would you accept that that might impact on the junction?
If the flows are different, it might impact on the junction.
Thank you, sir.
I agree with that.
I have
But
no
it
further
could have a
questions,
positive
sir.
impact, could have a negative, but without any modelling, very difficult for me to say anything further.
Thank you, sir.
Councillor Powell, have you finished? Then we'll move on to Mr Tilbury.
Just one question relating to your proof at 4.25 and just a couple of things in relation to that paragraph. You said it's not uncommon for large developments to be constructed in phases, with some development constructed at site access and marketing purposes, etc., which is true, of course, but is it fair to characterise this situation as another phase of a large development?
Tricky one. I would say yes, given the nature of the access to it, but it wasn't if what you're alluding to is it wasn't envisaged at the time that the Abbey View was constructed, then I think that's fair. It wasn't envisaged at that stage.
No, I mean, it's clearly not phased development, is it?
So not my intention to mislead clearly, but yes, minded to agree that that's perhaps not the best way to word that.
And just following up from that, leaving aside the consultant's use of the passive voice, which we will try to avoid, you've said it is not considered to be detrimental in relation to the development of the construction traffic. So it is not considered to be detrimental by whom, and it is not considered to be detrimental using what benchmark?
Not considered to be detrimental by me and my colleague who has been involved in this project, and as the benchmark as to whether something has a realistic prospect of causing a road safety issue.
So is there any standard or benchmark you can point to that would suggest that the inspector should follow your evidence rather than, for instance, that of the residents who live on the site, or indeed her own assessment?
There is no methodology for assessing this. I used the analogy earlier of a refuse vehicle, for instance, larger than the vast majority of construction vehicles. Residential estates such as this are designed to accommodate those. They happen on a regular basis. So I would apply a sort of common sense approach with mindful of refuse vehicles and other large vehicles such as delivery vehicles that already use these roads.
But not a judgment that relies upon expert advice?
I think anyone can make a reasonable judgment.
That'll do.
Okay.
You done, Mr. Tilbury? Right, thank you. I've got one more interested party, I think, wanted to ask a question. Mr. Listen, if you're happy to. Mr. Edge, did you want to ask a question? I'm so sorry, Mr. Free. Terrible. I was doing all right, to be fair, with names. I didn't do too badly. Are you happy to ask it from there, or would you like to come forward and use a? Okay.
It would be for the developer to do, well, firstly for the council in their capacity of signing off and agreeing the construction management plan. Then it becomes a matter of the developer to control their contractors through contracts and such like, construction contracts. And finally, the council would have the final control because they could use their enforcement powers in the event that the construction management plan wasn't adhered to.
During the later phases, we had very large coming through 4.8 metre road, and they would drive over the curves and leave them to get by. I am aware that by opening up the road by that situation, the light did put it, and the need barrier of road with respect to roadworks, that the actual passing space quite reduced between the existing curve and the new barrier. So it would be a question, how is that going to be protected for the residents?
Okay, so the first piece of work will be to widen the road. That will be done in sections. So half of the road will be effectively cordoned off to allow the contractor to gain access to widen the road, and that will be done in, I assume, relatively short sections, so there's good visibility from one end to the other, so that vehicles can pass in a single lane past that while those construction works are being done. Once those construction works are completed, then the HGVs will be able to pass, because we'll then be at the 5.5 metre width that's required to enable that to happen.
You were also aware that
Of course. Of course. Yeah.
Give us that reassurance that you get that indeed the junction between Keepsake Close and Cascade Way is very tight, and we're not really sure. We'd like some reassurance how they actually get round that bend, and there's a big concern.
I understand. So the construction management plan does not yet exist, and there's good reason for that, because at this stage we don't know who's going to build the houses, we don't know how they're going to be designed and constructed. So we can't do a meaningful construction management plan at this stage. Planning condition 17, I believe, deals with the construction management plan, so that will need to be agreed at a later date. It goes without saying, I hope, that construction management plan will need to ensure that emergency access is available to all dwellings at all times, and that will be one of its sort of important key purposes. At this stage, we haven't done that piece of work, so I perhaps can't give you that reassurance now, but it'd be normal in construction management plans for someone like myself to do swept path analysis, and that means we can drive around a whole host of different vehicles on a computer screen, and we would do that, and that would form part of the construction management plan. But at this stage, it doesn't exist for good reason. Yes, yes, I would. Yep. 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 But it is controlled by a planning condition, and rightly so.
Thank you, Mr. Free. Thank you, Mr. Bell. Mr. Howell, you have your hand up.
Yes, thank you, Mum. Driving here today, we got detoured quite extensively from coming from Farnham. The roads we went along were a lot narrower than the one we would normally use, and as a result, all the traffic was travelling a lot slower. Do you think that users of the road, if it was increased to 5.5, would go faster than they would if it was 4.8?
I dealt with this point earlier. No is my answer to that for two reasons. Firstly, that these roads in question are very lightly trafficked roads, and therefore would tend to only cater for one vehicle travelling at any one time in one direction. I'm not saying they never pass. Obviously, they do pass. But generally speaking, as any residents of these roads will know, generally just you driving along the road, and therefore the width has no bearing on your speed because there's no one coming the other way. It's only when you've got to pass a vehicle going the other way that you would need to slow down. Secondly, and more importantly, there are speed humps on these roads, and this is the speed humps that affect the vehicle speeds, not the road width.
The number of vehicles proposed, as we've heard this morning, has increased by 400
per day. Yeah.
Per day. That increases the traffic movements along the two roads substantially, don't you think?
I wouldn't say substantially. There are 120 units in the Taylor Wimpey scheme, Abbey View. We're increasing that by 80, which is an increase of two-thirds. I wouldn't say that's a significant increase. Furthermore, we tend to look at peak periods, those 1 hour periods in the morning and the afternoon. The increase we're predicting is around 50 vehicles during those 60-minute periods, which is less than one a minute, which I do not consider to be material.
So would you repeat this? Yeah, there's 50 vehicle movements in the 1 hour.
Correct. At peak times.
At peak times.
Off peak, the numbers will be significantly lower than that. And that 50 in an hour equates to less than one vehicle a minute. And a minute is longer than you think.
And how many vehicle movements do you think exist at the moment without the development along the two roads?
It depends where you record it, of course. But using my maths on the Crondall Lane and at the junction there, serving Abbey View, that's serving 120 at the moment. So it's going to be roughly, let me just get my maths, just roughly 50% higher than my 50. So about 75 at the moment at the Crondall Lane junction, and then at the entrance to our proposed development, there'd be about 50 from that point onwards. So the 75 goes up to 125, give or take.
So on Keepers Close,
Well,
ignoring Cascade Way?
I'd need to do the maths because I'd need to see at which point exactly. But if anyone else wants to do the maths, then typically one house will generate 5 vehicle movements in a day. So our 80 gets to 400 a day. That's multiplied by 5. Similarly, and just to keep the maths easy, 80 would typically result in about, multiply that by 0.5, and you get typically what you'd expect during the peak hours. In this case, 40. We're saying 50, so a little bit higher than that based on our projections. But you can do that maths at any point along any road, and it'll be roughly in the right ballpark. But it's very, I can't say Keepsake Close is X because there will be driveways on Keepsake Close, or whatever road you said, there'll be driveways there. So it depends at which point you want me to measure it.
But in Keepers Close, there's probably what, sort of 15 houses?
Yeah.
And you're adding 80?
15 times 5 would give you roughly the daily number of vehicle movements, 75.
So there is a substantial increase from 15 houses to 95 houses.
83 houses.
83 plus 15. So there's a substantial increase.
Yeah.
Would you agree?
Well, if the question is 83 a substantial increase over 15, you said, then yes. Yes, I would consider that to be a substantial increase based on.
There is a substantial difference. Yeah. Thank you.
Thank you, Mr. Howell. Right, there are no further questions from interested parties. Mr. Litton, was there anything that you wanted to raise?
Yes, just arising from that. Can you just explain, Mr. Bell, what Tempro, you referred to it a couple of times in response to Councillor Powell. What is Tempro and why do you use it?
We would normally obtain traffic data at one particular moment in time, in this case September 2022. We would agree a modelling period with the Highway Authority during pre-application discussions. In this case, that was 5 years post-planning application, which is normal, although not, other figures can be used, but that was the one used here, which took us to 2028. And therefore, it's appropriate to adjust the baseline traffic flows to simulate what they're likely to be in that study year, in this case 2028. We do that using Tempro, which is an industry standard bit of software, numbers in, numbers out kind of thing, and that takes account of general changes in traffic flow conditions, including the effects of COVID and such like, and also local plan allocations and committed development likely to take place during that period. It's not an overly precise science, but it's the industry standard, and that's what we've done here.
Oxbridge Farm, I think it was some time ago, also would any traffic increase associated with that be caught by Tempro?
I would expect it to be, yes. Yes, I can't say categorically without delving very deep into Tempro, but I would expect it to be, yes.
All right. And would it include any other committed development? What do you mean by committed development?
Schemes, local plan allocations and such like, really. Not necessarily small planning applications, which we would tend to deal with individually. We would normally establish whether any specific committed development needs to be considered in our modelling during pre-application discussions with the Highway Authority, and none were identified in this case.
And would committed developments include recently granted planning permissions?
Yes, correct.
All right. And I think that's it. Thank you very much. Thank you, Mr. Bell.
Mr. Bell, thank you. That was helpful. I don't have any further questions, so you're free to go back to your seat. Thank you.
Thank you.
Right, we will carry on. We'll give Mr. Bell a chance to stand down, and we will invite Mr. Petro to come up to the table. Mr. Green, if you would like to take your witness. Thank you. This is the commencement for the benefit of anybody that's watching the live stream or that are here of the landscape evidence. So this is the first topic that we'll be dealing with. Whilst Mr. Petro is getting comfortable, I mentioned earlier about the site visit and how I would be happy to, if there were requests to view from particular properties, I'd be happy to take those. And Mr. Free, there was some correspondence between yourself and the case officer about possible requests to view from properties. So perhaps if the local residents, if there are any, could put those forward perhaps to the council, and then we can arrange for that to take place on the site visit. Okay? Thank you. Mr. Green, sorry to interrupt when I said I wouldn't, but you hadn't started yet.
I
so-
hadn't started.
But please, when you're ready.
Thank you very much, madam. Let me introduce Mr. Petro first. Your name is Robert Petro. You're a chartered landscape architect and the managing director of Petro Harley Limited. You have a national certificate and national diploma in horticulture from Marist Wood College and a Bachelor of Arts honours degree and postgraduate honours diploma in landscape architecture from Greenwich University. You're a chartered member of the Landscape Institute, and as you say in your proof, you have over 30 years experience in landscape design. Is that correct? Thank you very much. You produced a proof of evidence, and section 9 of that proof is a summary and conclusions section. And given that there are third parties here, I think it would perhaps be best if you first read out your summary and conclusions section. It's only a couple of pages, and then I shall ask you some supplementary questions.
Okay, good afternoon. So I'm starting from 9 summary conclusions, 9.1. The appeal concerns proposals for up to 83 dwellings within a greenfield site outside the settlement boundary. The site lies within the countryside, but outside of any national designations or valued landscapes, which have the highest status of protection. It does, however, lie within the countryside and the local designation area of strategic visual importance, ASVI. National related planning policy. National and development plan policies expect new development to recognise the intrinsic character and beauty of the countryside, respect and, where appropriate, enhance the distinctive character of the landscape of Waverley Borough, recognise the distinctive character and pattern of development, be sympathetic to the natural built form and historic character, and maintain a strong sense of place. At a county level, the site lies within type LF, rolling clay farmland, that's landscape character area LF6, North Farm rolling clay land, and LCA4 castle paddocks area. Both studies identify the site as being rural and providing a soft edge to the settlement, which filters view of the town and maintains the rural character of the landscape. The key character is that of open countryside with a limited settlement of scattered farmsteads. I consider the Peel site itself has a medium value and high sensitivity. The next section is landscape effects. The appeal proposals would result in the loss of the open countryside to residential development. I consider that the landscape effects would be high adverse during construction and year 1, reducing to medium adverse by year 15. The landscape effects of new built form within the countryside and ASVI are permanent and cannot be mitigated. Visual effects. There are views towards the site from residential receptors, recreational users, public footpath and road users. My assessment is that the Peel site has a medium adverse effect from adjacent road network and high adverse from public footpaths. Planting would attempt to screen views, but screening afforded may not be effective for 15 years. The site lies within an area of strategic visual importance, ASVI, the purpose of which is to maintain open areas of undeveloped land that stretch into the urban area. I consider that the site contributes to maintaining the urban character of Farnham by virtue of its open and undeveloped character, which provides a soft and distinct edge to the urban area. The ASVI in this location makes a key contribution to the character of Farnham by virtue of its sort of slightly lost, or its undeveloped character and providing a soft settlement edge. Under the proposals, this would be replaced with new housing and the rural qualities of the site would be harmed. This part of the ASAVI would be changed and the key qualities of an open, rural and undeveloped landscape would be replaced with a new built form. This would increase the loss of an important link to the broader countryside and would be viewed as built form encroaching into open countryside and a harmful sense of increased urbanisation. Landscaping proposals have been provided with all matters reserved except access to demonstrate one way that landscape proposals for the scheme could be arranged. In my view, there is insufficient space within the housing areas to provide meaningful planting that provide tree-lined streets as suggested. Although the public footpaths are retained and a new connection provided along the southern edge of the scheme, the user experience would change from passing through open countryside to that of walking through an area of housing. Whilst boundary planting is proposed and some new hedgerows provided, it is unlikely that these would be successful concealing the development from the public footpaths and the wider ASVI landscape. The development of undeveloped land fundamentally alters the existing rural landscape character as identified with the two landscape character assessments. This would increase the loss of an important link to the broader countryside and be viewed as built form encroaching into the open countryside and a harbour sense of increased urbanisation.
Thank you very much. The parties have agreed a landscape statement of common ground.
Yeah.
And I think it's helpful to turn to that. It's CD 8.4. And as is common, indeed, as is intrinsic to these documents, it sets out matters of agreement and matters of disagreement. And perhaps most helpfully for the inspector, I just want to explore the areas of disagreement and to find out why you disagree. If we can go to Appendix 4 first of all, that breaks down the assessment that both you and Mazid have carried out into an assessment of, if you like, landscape impacts and then visual impacts. I'm going to focus on the landscape impacts first.
So are we under heading 4 or?
Appendix 4 in the landscape statement of common ground.
Okay.
We have the table there, and I mean, as one looks through the table, one can see that actually you, Mazid, are broadly agreed on most, I think, impacts, but there are some that you're not agreed on, and the first two impacts relate to landscape receptors, as they're called, two different landscape character areas, depending on whether you're looking at the Surrey landscape character assessment or the smaller scale Farnham character assessment. And one can see there, there are differences in your assessments. Your assessment, where you refer to magnitudes of effect and levels of effect and so on as high adverse, were you considering there the whole character area, or were you considering the appeal site as a component of the character area?
It's the latter, it's the appeal site as a component of the wider landscape.
Just to understand what difference that makes, can you go back to page 10 of the landscape statement of common ground? And one can see on page 10, there's an extract, figure 3.4, plan showing the extent of the landscape character area there, North Farnham, Rolling Clay Farmlands, taken from the Surrey landscape character assessment. And one can see the appeal site outlined in red is a small part of that larger landscape character area.
That's right. So that puts it in some sort of context. You can see how the appeal site relates to the broader, the wider landscape area.
So if you were asked what is the effect of the proposed development on the entire landscape character area, what would your assessment be?
It's the area in red within that wider landscape area. So it's that relatively small part of the whole area of LF6.
Okay, so if one returns then to the table we were looking at in Appendix 4, where you refer to magnitudes of effect and levels of effect as high adverse.
Yeah.
That relates what, to the appeal site or the larger character area?
Appeal site.
The appeal site, okay. If one was going to ask oneself what would the effect of the proposed development be on the entire landscape character area, what would your assessment be?
The same. It's an adverse effect within that area identified by the red line.
Okay. If, however, one was looking not simply the effect of the development on the appeal site, but on the entire, if one goes to page 10 and looks at the entire landscape character area, what would the effect of the proposed development be on that larger landscape character area?
It would affect that small part of the wider landscape area.
So what would the overall effect be?
Well, as a
assessing,
it'd be minor adverse on the whole area. So
that's quite right.
Keep up your question.
So if you go back to the table, Appendix 4, first part of which is looking at the landscape character area, would you agree or disagree, assuming, as I say, we're looking at the effect of the development on the entire landscape character area, not the appeal?
I would agree with the appellant's effects.
Would you agree or disagree?
Agree.
Agree.
Sorry,
Yeah.
Yes.
what's the matter, Mr. Tilbury? Ah,
Of course.
Mr. Petro, sorry, there's some issues
Is that better?
with the volume.
Yes, I'm afraid these microphones are a bit, well, mercurial. Some are more sensitive than others, so some you have to get much closer to.
Mr. Green, could you ask that question again? Because
Of
I
course,
got a bit lost in my
absolutely.
notes then.
Looking at the effect of the proposed development on the landscape character, the North Rolling Clay Farmland landscape character as a whole, would you agree or disagree with the appellant's assessment?
Agree.
Now, if one's looking not at that character area, but at the different one, if one goes now to page 12 of the Statement of Common Ground, we can see that this is an extract from a different character assessment, the Farnham landscape character assessment, that divides the area up into different character areas. And we can see the appeal site there outlined in red forms part of the smaller landscape area, landscape character area number 4. Assuming that one's looking at the effect of the proposed development on that landscape character area number 4, so not confining oneself to the appeal site, but to the entirety of that landscape character area 4, would you agree or disagree with the assessment that we find in the table?
I need to go back to the table.
Yes.
I disagree in that is given as being moderate adverse. My assessment, that's high adverse, year 1. And my view is that adverse effect continues through to year 15 by virtue of the change in landscape character from open countryside to built form.
And just to be clear, in saying that, you're looking not just at the appeal site, you're looking at the entirety of the landscape character area 4.
No. Because there's a further subdivision looking at the application site in relation to LC4.
Yes. So if I was looking at the effect of
I misunderstood the question. So I'm going to go back and say I agree that it would be moderate adverse within LC4, but then going back to look at the application site as a part of LC4.
Yeah. Thank you. That was that we're looking at those 2 landscape character areas. Now, given your answers and given your agreement when looking at the entirety of the landscape character areas concerned, not just the appeal site, it may be that there's less to explore here, but going to page 11 again of the landscape statement of common ground. Paragraph 3.14 sets out, it repeats the key positive landscape attributes that one finds in the Surrey landscape character assessment for the North Farnham rolling clay farmlands. And one can see there are 6 bullets there.
Could you go back to the page again? I've got
page 11. Paragraph 3.14. I'm not going to the original documents because this helpfully sets out the relevant extracts.
Okay.
So one can see there 6 bullets, areas of peaceful rural farm, a network of hedgerows, etc., woodland blocks, etc. How likely is it that one would find all those key attributes on a single development site?
It's extremely unlikely, and that we're looking at a fairly large area of landscape, and these are some of the key kind of bullet points that within that whole wide landscape area one might expect to find. So there's obviously going to be variation field to field, area to area. So it's extremely unlikely that all of those bullet points will occur in one area, one red application line area. So it's trying to give an overall feel for what defines that area of landscape.
Thank you. Now, the other area of disagreement concerns not landscape effects, but visual effects.
Yeah.
Go back to Appendix 4. One can see in Table 6.1 onward summary of effects on visual receptors, and what you both have done here is to look at different receptors, it's said. I mean, frankly, people at different locations and the effect the proposed development
it's a user experience. It's people's views from a public footpath or from a building or something else.
Yes, and we can see, although you agree on many of the viewpoints, there are some you don't concerning footpaths. Regarding the footpaths in and around the site, the LVA says that the footpaths appear to be reasonably well used. What's your view of that?
I visited the site and walked the footpaths on a weekday, and because I was interested, I walked the same footpaths at a weekend. During the weekday, the footpaths were certainly well used. At a weekend, they are very, very well used. There was a huge variety of people, different age groups, different types, walking dogs, people jogging, ramblers, people with buggies. And as one would expect, being so close to an urban area and offering really good access so close by, the footpaths were very, very well used.
Thank you. Now, we have guidance in a document commonly called Glivia. I don't know if you have a copy of that to hand.
I rather foolishly left it in my bag, which is by my chair.
Well, perhaps Mr. Sampson can get that.
Full document now is on the council's website.
Excellent. So for those who are looking at it electronically, it's 6.3, CD 6.3. And I'm going to go to page 113. It's the internal page.
And the other pages are about 10, 12 out. Internal page 1.
Yes.
It's that, if you, does that help? Yeah.
This is the principal document that guides these sorts of landscape and visual assessments. And at 113, we have guidance on assessing the significance of visual effects. And it starts with a look at the sensitivity of visual receptors. And that in turn is broken down into a number of components, one of which is susceptibility. What does it say at paragraph 6.33 about the susceptibility of certain visual receptors?
It's about the expectation of the view, is why people are taking that view. So in this case, we're looking at or considering views from public footpaths. So people are walking those footpaths to obtain a view and experience of the rural landscape. That's why they're there. They're going for a walk in the countryside, they join to the countryside, and the moment they experience open views across the countryside. So the expectation is that of a view of pleasant rural landscapes. That's why they're there. That's their experience. And that view is sensitive to change because it's free of built development. It's open rural landscape.
Mr. Petro, just for the benefit of third parties who don't have Glivia to heart or to hand, I will just read out the first few sentences at 6.33. The visual receptors most susceptible to change are generally likely to include residents at home and people, whether residents or visitors, who are engaged in outdoor recreation, including use of public rights of way, whose attention or interest is likely to be focused on the landscape and on particular views. To what extent are users of the footpaths that cross and skirt the appeal site likely to be focused on the landscape and on views?
In their entirety. That's why they're there. They're experiencing a pleasant rural view. They've made an active choice to walk that footpath to take in that view.
The number of footpaths and the permeability of the appeal site, to what extent is that usual, typical, or unusual?
In my experience, it's fairly unusual to have 3 footpaths that are reasonably close together and afford such really excellent access from an urban area immediately into the open countryside. in my view, that's pretty much unique. You might have, one footpath, even maybe two, but have three, all within, a couple of minute walk of each other is unusual and really good.
Returning then to table 6.1, the summary of effects on visual receptors. We can see there are areas of disagreement. First receptor, users of public footpaths, references 7 and 94. We can see that Mazid has given them a sensitivity rating of medium to high.
Is it worth the inspector understanding where those footpaths are, or do you know where they are? Okay. Sorry, I interrupted you.
So Mazid says medium to high sensitivity. You say high. Why?
I put that firmly in high because of the location adjacent to the urban edge and this, really great access virtually from people's front doors into the open countryside. They have an amazing chance to get into the countryside so quickly. There's no sort of urban fringe characteristics. There's no kind of transition from urban to rural. You're virtually straight away in this rural landscape. And in my view, because of the location, because of the access, the ease of access, and the number of people who are regularly using that paths, I put that firmly in high.
Oh, that sensitivity, then you take a different view on the magnitude of effect after 1 year and indeed 15 years. Why is that?
Because that view is going to permanently change from open rural landscape to built form. And for the duration of those footpaths, at the moment, you're in open rural landscape, countryside. You won't be. You will be within the confines of a settlement. Even when you're not passing the housing, you'll be aware of the housing and the change of that landscape character changes from open countryside to settlement, to housing.
Moving on then to the next receptor identified, users of the St Swithin's Way long distance footpath. Again, Mazid says medium to high sensitivity and moderate adverse effects. What's your view?
I put that firmly in high again. There's a slight there's more a variation modelling often that footpath that footpath emerges from between the university buildings. There's a fairly short section of the footpath. You're walking through the open rural landscape. The footpath kind of turns a slight right, and you go between two garden spaces. The footpath's a lot more narrow, and you emerge up onto the road. Then either you carry left towards the ADLV, or you turn right back towards Farnham Castle and what I call the High Street. And back towards the church. So the bit of concern here particularly is as the footpath emerges from the university buildings and enters the open countryside.
Thank you. Now, the last of these receptors, users of public rights of way and public open space to the west of the site. We have again the same difference, medium high for Mazid and high for you in terms of sensitivity. Again, why the difference?
Because from their open space, certainly looking east, you're looking over the site and over undeveloped rural landscape, over the countryside. Those views would change to built form.
Ultimately, of course, the inspector will have to reach her own judgment on all these matters, so I'm not going to take that any further.
And the inspector will walk in the footpaths and
Yes.
you'll see.
Yes, absolutely. Just one further issue. You commented on the landscape proposals and questioned whether or not they were sufficient to allow significant tree planting. And in response to that, we have a rebuttal proof that was put in which proposed alternative illustrative landscaping strategy. Have you had a chance to look at that?
I have, and
what view do you
those
take?
drawings are an awful lot clearer. And I would concede the point, there is space within the scheme for tree-lined streets. The first set of plans looking at didn't seem to show that. The second, more refined sets of plans do show it. And I agree there is space for street tree planting.
Thank you very much. There may be some questions for you.
Thank you, Mr. Green. Mr. Lisson, when you're ready.
Thank you. Good afternoon, Mr. Petro.
Good afternoon.
Mr. Petro, you obviously been brought into this case relatively recently to give the evidence in support of the council's reasons for refusal. Can you just remind me when you came into this case, please?
It would have been in the region of, actually it was quite short, it was December last year.
And you had no previous involvement, did you?
No.
I wanted just to start, please, with the case officer's report, which is at CD 4.2 and is also in the core bundle. I don't know whether you have that. Do you have you have everything electronically, I think, do you? It should be volume 1 of 2 if you've got the paper copy.
Yep.
And it should be tabbed starting at 4. So that's core documents 4.
Yep.
And in that, you will see, I'm afraid it's not helpfully then numbered, but the first document is the decision letter. And then you've got the report behind it. That is CD 4.2.
Mr. Petro, you might want to use the paper copies here, if that would be helpful.
There is a good idea. Thank you. Thank you. I'm with you.
And again, there aren't any internal page numbers in the officer's report or indeed paragraph numbers. There are section numbers.
Okay.
But if you turn in that document to a heading that says other material considerations, so about 4 or 5 pages into that document, it says other material considerations, the right-hand side.
Odd enough, I found it straight away.
Yeah, brilliant. And then, if you turn on 2 more pages, you'll find a section headed Impact on Countryside Beyond the Greenbelt and Landscape Character.
Yep.
And that tells us a number of things that are agreed about the location of the site in various landscape designations. And if you turn on in that section, sorry. I've now lost my reference. Yeah, if you turn on 2 more pages, you come to the end of that section, and then there's a new section that starts impact on trees.
Mm-hmm.
On the left-hand side. So it's the paragraph immediately above that where the case officer comes to a conclusion in relation to the landscape impacts and recognizes that it's outside the built-up area boundary. It's adjacent to the new Abbey View residential development. And she concludes, as such, the proposal complies with policy RE1 and RE3 of the local plan, and then policies 1, 10, and 11 of the neighbourhood plan. So that was her conclusion, professional conclusion reached.
So this is the one by Michael Easton, or?
Michael Easton, is it? Did I say she?
Yeah.
Michael Easton, he.
That doesn't really matter. I happen to know Michael, that's all.
Okay. So the conclusion of the case officer, Mr. Easton, was that actually it complied with those policies in LPP1 and the Farnham Neighbourhood Plan.
That's correct.
Correct. You, I assume, disagree with that professional conclusion?
Well, as stated in my proof, it's to do with the effect upon the landscape, change in landscape character and the views.
Yeah. All right. There wasn't any criticism by the officer, Mr. Easton, of the LVA that was submitted by the appellant, was there?
No, and nor do I.
Well, you don't criticise the methodology.
It's methodology, yes.
Yeah, you arrive, you say at different judgments.
Yes.
But in terms of the methodology that is employed, it uses looks to Glivia 3, etc., and the inspector can be confident that there is no methodological difference.
It's all sound, yeah.
Yeah. Okay. Good. Now, can I ask you, please, then about your approach? So, if we take up your proof of evidence, your section 3, page 5, says that you have used the Glivia 3 3rd edition guidance in terms of your methodology in preparing your proof of evidence.
Yeah, so what I'm effectively doing here is a review of their LVA.
Yeah.
And deciding where I'm going to agree or disagree with the judgments.
Yeah. And you also say that you've had regard to the Institute's notes and clarifications on aspects of the guidelines. That was the more recent update in August of 2024. Now, as you say, you've done a review. You haven't undertaken a fresh baseline assessment, have you?
There's no need. We don't disagree.
No. Okay. And your methodology is then set out, isn't it, in your appendices? So you appendix
I'm just trying to add some clarification for the inspector to understand where we're using some of these terms, where these terms have come from.
Yeah. Now, I mean, it is important, an important aspect, if necessary, we'll go and look at all the references in Glivia, that when you're doing an assessment, or indeed if you are reviewing an assessment, and particularly if you are coming to different judgments on matters arising from that assessment, that you are transparent in terms of how you arrive at those assessments. That's correct,
Yes.
isn't it?
Yes.
Yeah. Because transparency allows the judgment calls that you make as a professional to be tested and examined.
Correct.
All right. Now, both in terms of landscape impacts, but also visual impacts, in order to arrive at an assessment of the significant effects, it's a combination of judgments made on the sensitivity of the receptor. In the case of the landscape, the receiving landscape, it could be a character area or whatever, and the magnitude of change.
Correct.
There is a prior step, though, isn't there, to understanding sensitivity, because sensitivity is a combination of two components, value and susceptibility.
Yeah.
And that is the case whether you're looking at the landscape impacts or indeed the visual impacts.
Yes.
Yeah. And in Appendix A to your proof of evidence, you have Table 1, a table which helps to explain the criteria that are used in order to arrive at the landscape value. Yeah.
I'm with you.
And then over the page, you have at Table 2, a similar table that helps one arrive at what the susceptibility is.
Yes.
Which, when you combine those, gives you your sensitivity.
Correct.
And that's your Table 3,
Yeah.
which, as we know, you then combine with the magnitude of impact to arrive at the significance of the effect.
Yes.
Now, we're going to come back to some of these in a moment too. Visual assessment, which is at section 5 or page 5 of your appendices. What you don't have here is a table for value or a table for susceptibility. You just have a single table for visual sensitivity, i.e. the sensitivity component to be combined with magnitude to arrive at significance of effect.
Okay.
Yes, that's correct, isn't it, as a matter of fact? So when we look at your evidence and your assessment of sensitivity, we have no idea as to how you have combined value and susceptibility to arrive at sensitivity, do we?
No, but I think we've explained that in the proof and the conversation we just had.
Well, certainly in the proof, there is nothing
No,
there.
I take your point, yeah.
No, sorry, let me finish the question and then you can answer it. Sorry, Mr. Petrol, otherwise we'll get terribly confused. But it's correct, isn't it, that you do not set out in your proof of evidence any assessment of value or susceptibility in relation to the visual impact assessment, do you?
Correct.
Correct. Now, given that we've already agreed the importance of transparency advised by Glivia, that's a pretty big omission, isn't it?
With the benefit of hindsight, yes.
Yeah, all right, thank you. All right, now, let me just jump back then to landscape, where, as I say, you do have two tables on landscape value and susceptibility. Now, if we look at the statement of common ground, actually, no, let's look at your proof of evidence. Otherwise, I'm jumping between too many documents. So you have in your table on page 14 of your proof of evidence, table 3, your assessment of the landscape effects.
Yes.
Now, I think we've actually moved on, haven't we? Because in relation to LCA LF6, so the Surrey-wide character area, and LCA 4, actually you have moved your position away from it being high adverse in both those occasions to agreeing with the appellant in the statement of common ground.
Perhaps I should have been clear. It's high adverse, but high adverse within a small area of, rather than high adverse over the whole area.
Well, I don't really understand that, I have to confess, because there is a separate category where you look at the application site.
Because we're attempting to break the landscape down into component parts and to area parts. So I think what's important here to consider is that let's take LF6 as an example. LF6 is a big area. I accept that the application site or the appeal site is a small part of that. And I maintain that there is an adverse landscape effect within that small part of it. So I'm saying there is a moderate adverse effect within that landscape character type, but it's within the red line area.
Yeah, but my point is...
I hope I'm being clearer than perhaps, well,
I'm just going to test this a little bit, I'm afraid, Mr. Petro, because when in your table, on that left-hand column, you have identified a whole series of potential receptors.
Correct.
Okay, and so one receptor was LF6, another receptor was LCA4.
Yes.
Then you had the Northwest Farnham residential area. Then you had the application site or the appeal site. They were different receptors that you were assessing.
No, they're...
Yes, they are. That's why they have their own rows.
Let me continue in the same way. I give the courtesy of not interrupting you, and please extend the same. The application site is a part of a wider landscape. A landscape is a sum of its parts. So I'm attempting to divide those sum of the parts down into discrete areas and understand and describe what the effects are.
Yes, for each receptor. And your evidence was that in relation to LCA6 and LCA4, which are different receptors to the appeal site, you had concluded that there would be a high adverse impact for both of those receptors in year one.
But the appeal site is part of those landscape receptors too.
Yes, and you also had a high adverse impact in relation to the appeal site.
Yes. So I'm saying the application site itself as a discrete area has a high adverse landscape effect. I don't think we're disagreeing with that. Within the broader landscape, that part of the site that is affected by these proposals has an adverse effect too. But it's a localized adverse effect within the broader landscape. So we're trying, maybe it hasn't worked, to try to describe what the effects are within those different landscape character areas, but they're all conjoined. You're just trying to divide it down to give a sort of a clearer picture.
As I say, the position has moved, as far as I'm concerned, I'll be making that submission, to what you have now said in your evidence in chief, that you agree with the appellant's assessment in relation to LC6, LCA4 in the statement of common ground. So I don't want to waste a lot more time on that.
Yeah. Well, I think we are agreeing in a rather long-winded way.
So the remaining area of disagreement between the parties on landscape effects is in relation to the appeal site.
Correct.
Right. Now, for the landscape effects, you undertake an analysis in your table 1 and your table 2, although they are headed slightly differently. So if I turn to your table 1 on page 10, this is your analysis, and I think the only analysis, of how you get to a landscape sensitivity for the application site or the appeal site of high.
Yes.
Yeah. And what you've done is you say in this table the landscape value is medium, the landscape susceptibility is high, that gives you a high sensitivity for the appeal site. There is no narrative, is there, to explain how you get to a landscape value of medium or a landscape susceptibility of high?
I described susceptibility and value over the page at 9. No, sorry, I don't. I'm getting confused. Hang on. So in page 6, I attempt to describe landscape quality, value, susceptibility and sensitivity.
Well, no, all you're doing there, with the greatest respect, is you're explaining what landscape sensitivity is, you describe what landscape value is, and you describe what susceptibility is.
Okay.
You don't actually carry out an analysis of what the value of the appeal site is or what the susceptibility of the appeal site is. That's just descriptive of the terms.
Agree.
Yeah. So I'm right, aren't I, that actually there is no analysis in this document of how, or no narrative of, to explain to the inspector of how you get to a landscape value of medium or a landscape susceptibility of high.
I agree.
Yeah. Well, I'm going to try and help you out here.
Gosh.
It's taken me a while. Because in your Appendix A, you do have these two tables that explain landscape value and landscape susceptibility. These are not tables that are bespoke to this appeal site. These are sort of generic tables that you use to guide the assessment of value and susceptibility. So if we just take landscape susceptibility, because that I think is where the real difference is between you and in Miss Eade. You say landscape susceptibility of the appeal site is high. We turn to table 2 in your appendices. We can see the scale and we can see what a landscape which has high susceptibility should comprise. And you give some criteria there. So if it's going to be high, it should be a landscape with a low capacity to accommodate the type of development being proposed, owing to the interactions of topography, vegetation, cover, built form, etc., i.e. wide open countryside. Is the appeal site wide open countryside?
Well, this is a rather general. It's certainly countryside.
Okay.
I wouldn't call it wide open, no, but it is open countryside.
Open countryside, but not wide.
It's not wide in that there aren't, miles and miles of views, but it's open countryside. But I think,
all right, then
it's trying to apply judgment and common sense to how we're using these terms.
Yeah, nature of land use, landscapes with no or little existing reference or context to the type of development being proposed. You're not going to suggest that because you've got Abbey View immediately to the southwest, and you've got the University of Creative Arts immediately to the south, and indeed I think there is further development, albeit sporadic, further to the west. So that doesn't help you get it into the high category, does it?
Well, it does and it doesn't, and it's an accepted fact that there's an urban edge abuts the site, but within the appeal site itself, there is no built form, there's no reference to built form or a transition of built form into the site. So I think the susceptibility of the site here is important in that it provides that break, that distinct change from urban to rural. So yes, as you move through, you're aware of the urban edge, and as you move further away, it's more in the distance. But the reference is the break that it provides, and that, for me, is one of the key important qualities of this landscape and why it's got high susceptibility, is this fantastic change, a very abrupt change from urban to rural, and it's quite unique and really very, very interesting, quite attractive.
I have to say,
and for that reason, I think the site has high high susceptibility.
Well, I'm just going to go through these because I'm testing this because we've got no narrative. You provide no explanation as to why you get to a high.
Well, we
level.
take the point. That's what
Sorry.
we're discussing, isn't it? I'm sorry to interrupt you. I apologise.
I'm going through each of these criteria to understand it because there is simply no narrative or explanation in your proof of evidence, Mr. Petro. So we've accepted, you've agreed that it is open countryside, but not wide open countryside. That's the first of the criteria.
Agreed.
In relation to the second criteria, you say that it is that the appeal site is a landscape which has no or little existing reference or context to the type of development being proposed. That's your position, is it?
So can you repeat the question?
Yeah. Look at the criteria. Criterion 2 for a landscape with high susceptibility is one that has no or little existing reference or context to the type of development being proposed. The type of development being proposed is housing. Okay. It plainly has reference and context to Abbey View, but also to the university. That's its reference and context, isn't it?
No, I take the point you're making, but I think we'll come back to the issue that, yes, you're aware of the urban edge at the site. And of course, that forms some context, but it's the context of how that site then provides the break and how there's no kind of spilling out of that urban edge into the site. So the site itself doesn't have that context of an urban fringe characteristics, horticulture, stables, other buildings. And so I think that my view, and maybe we're not going to agree, is that the context, the reference is the open countryside at the edge of Farnham.
Okay, the next criteria, please, nature of existing elements, so a landscape with components that are not easily replaced or substituted. And then it gives example, ancient woodland, mature trees, historic parkland. You are not suggesting that the appeal site, because that's what we're focused on, the appeal site is one which has components that are not easily replaced, such as ancient woodland, mature trees, or historic parkland, are you?
Agreed.
Good. Fourth criteria, nature of existing features. So landscape where detracting features, major infrastructure or industry is not present, or where present has a limited influence on the landscape character. Where do you stand on that?
So what's the question, please?
Well, I just have. Where do you stand in relation to that criteria? You obviously haven't thought about it.
No, you let me think. I'm trying.
Well, I said that's why you obviously haven't thought about it, because there's no narrative in your text.
Well, I'm doing my best to follow the conversation. Sitting, listening, thinking, and talking. It takes me a couple of seconds just to get it into gear. So, you can try and rush me. You're welcome to, but I'm doing my best to answer your questions. Nature existing features. There's a detracting feature in that there's the urban edge. We accept that. But in my view, it's not a major influence upon the landscape character. The landscape character comes back to it being open countryside. And the issue about how it provides the break, how it provides an amazing resource of people using it via the public footpaths, and the access it provides, and the benefits it provides to people who can escape so quickly from an urban edge into an area of open landscape. So it comes back to the point, there is the edge, the urban edge to the site, but the site it still is open countryside and has many attractive qualities.
Okay.
And the change, susceptibility is about the ability of that site to accept that change, that undue consequences. There is a large consequence, undue consequence of the site going from open countryside or rural character to residential built form. That's why I put it in high. It's a judgment call, but that's my judgment.
Okay. All right. Can I then please just ask you, in terms of the landscape value of the appeal site, you say it is medium.
Yeah, I agree.
And if we look at your appendix, table 1 in appendix A, then for it to be medium, it is typically undesignated landscape. We agree with that, I think, do we?
Well, it's a local designation, it's not a national designation.
Okay.
And their local designation, sorry, interrupt you. The local designation about its is visual appeal, its openness.
Yeah, okay. Has a moderate level of tranquility. Does it have rare or distinctive landscape elements?
No.
Is it medium importance and rarity in a regional scale or limited potential for substitution? The last line of your appendix A and the medium category.
I'd agree.
Okay. What I then want, please, to do is
Mr. Listen, I don't want to disrupt your train of thought or anything. However, if you could find a convenient break at some point where your questioning might have a break so that we can take a comfort break, I'd be
yes, of
grateful.
course.
No
Yeah.
immediate rush, but that would be something to be mindful of. Thank you.
And if we just then look, please, at the statement of common ground and the table at Appendix 4.
Do I need a hard copy or can I just get going from what you're saying?
Yeah, do you have the hard copy? It's probably in that ring binder. Oh, no.
That will be the incomplete one that's in the ring binder, I
is-
think.
Ah.
I can call up, it'll take me a couple of seconds. to
Well,
write
it's
that.
CD 8.4.
I've got to get up. I managed to click the wrong button. I've turned it off my computer. Do you read it out?
Yeah, CD. So CD 8.4. It's the table that Mr. Green took you to in your evidence in chief. And that first table deals with the landscape impacts, and then over the page has a table number 6.1. That's the visual receptors. But I'm on the landscape and the application site because we've agreed the position in relation to LF6 and LCA4. So the application site. Just so I'm entirely clear, the assessment, the appellant's assessment of the sensitivity of the appeal site being medium, do you agree with that?
I called it up, so I'm
Yes,
gonna be-
right.
I'm going to be a
Wait, tell me when you've got it up.
bit of a pain, so I should have. Here we go. Okay, I'm with you. So
Yeah, so
the microphone closer.
The first table in Appendix 4.
So where are we in terms of CD documents?
Sorry.
I'm back to CD
8.4.
8. My apologies. I'm with you.
Okay. So the first table, it doesn't have a table number, but it's the first table in Appendix 4. This is dealing with the landscape effects. This is the document that Mr. Green asked you in evidence in chief. You agreed that actually your position is not that there is high adverse magnitude of effects or level of effects for either LC5, LF6 or LCA4. You agreed that the appellant's assessment is correct.
Yes.
Yeah. So that's why we're just looking at the application side. Now, the council's position is in the right-hand column. The sensitivity is in this document assessed by Ms. Eade as being, for the application side, is being assessed as medium. Do you agree with that? You haven't disagreed with it?
I would put it towards medium high.
Right. Okay.
So I don't. Yeah, medium high.
Medium high. So that's then a departure from your proof of evidence as well, is it?
What do I say my proof?
High.
I'm trying to make life a little bit easier. I mean, I think it's it's in the high range of medium high, but I would accept medium high rather than high.
Right. It is a change from your proof of evidence.
A minor change. Yes.
Yeah.
I'm trying to get the disagreement down as much as possible so that make the inspector's life a bit easier.
Then we see you've got the magnitude of effect as being high adverse, and you say now that is driven. Sorry, the level of effect high adverse, and that is because you have a combination of what you now say is a high medium sensitivity and a high adverse magnitude of effect.
Yes.
And you say there's simply no change between year 1 and year 15.
No.
You say that whatever the appellant does in terms of the landscaping, etc., it's not going to have an effect.
I think there is a case to be made for mitigation for reducing that effect, but I think that effect, in my view, my opinion, is always to be high adverse because of this fundamental change from rural to built form. Yes, mitigation would attempt to, if you like, make the best of a bad job, but that mitigation is never going to mitigate that fundamental change.
Yeah, okay, I've heard this argument before. I mean, that means that means that wherever you have, for example, a greenfield site in the countryside which has housing development on it, doesn't matter what landscaping you do, because you have replaced a greenfield with housing development, the significance of the effect will always be adverse, whether it's at year 1, year 15, year 25. That's your position, is it?
Yeah.
Yeah. Okay. Right. Then in terms of the visual receptors, oh, sorry, madam, I'm going to turn to visual receptors. So why don't we, is now a convenient time? Yeah. Yeah.
We probably should break. So yeah. Right. Okay. That's splendid. I think everyone could do the 15 minutes. Mr. Petro, obviously you're in the middle of examination.
I'll keep away from people.
Please keep away from everybody. And we will adjourn now and reconvene at 4:15. Thank you. So I addressed timetable issues earlier. So the site visit will either take place on Thursday afternoon or the Friday evening.
Which I don't think is very good. Thank you. No, that's.
In chief, I think probably only, oh, it's just gotten a bit shorter, probably about half an hour, I would think. I'd like to get her done this afternoon, if possible, in chief at least, and then start cross-examination tomorrow, if that's all right, Robin. Thank you. Switch, should we go to bed?
So the bit on the, so, we go to his table, this is in his.
Oh, yeah. Mention, he says hi.
Well, this is when you're combining value and susceptibility, when you combine medium susceptibility.
But he said high susceptibility. That's, he doesn't mean.
He's got it, I mean, basically, medium plus high.
I mean, he says it's
medium plus
susceptibility.
high gives you medium high, not
I mean,
high.
this should be susceptibility,
Yeah,
shouldn't it?
Yeah.
So he says, but he said.
He's in his.
No, but he was talking about it being sensitivity.
Yeah, he's saying sensitivity, which is a function of value and susceptibility, that should be medium high.
Medium and high should be medium high. Well, that's what he said now, isn't it?
That's now where he's got to, yeah.
Yeah.
The other thing he might get back to in his examinations, he does here. Susceptibility.
Yeah, but I mean, there's no analysis. Nowhere do we see how he gets to its values of and that's what we're going to do next, because, you know, well, how? But I mean, if we then look at the LVA, sorry, and use that as a proxy. Then we see what? Well, this is your.
That's mine, yeah.
Yes. Well, I mean, he hasn't got anything. He hasn't
Oh,
got
no,
anything.
no, no.
So I mean,
Yeah.
I'm testing his evidence that they are, both value and susceptibility for vision assessment is high.
Yeah.
We don't know how he's arrived at that, because that's just sensitivity.
But
Yes.
it says it's value here. So is that high value sensitivity?
Okay, but if that's, but he,
It's not.
well, I mean, he's already accepted evidence that he doesn't have any tables for susceptibility or value
No.
to arrive at sensitivity.
No.
So you've already accepted that. Move on from that.
Yeah.
So anyway, he hasn't got those tables. So the closest we've got is what's in the LBA, which he hasn't disagreed with.
No. No.
So to test his assessment of them being high, sensitivity, to test his so to test his analysis or assessment, these are both high. I haven't got anything to go on other than this.
So that's one we've agreed to.
So but value, yeah.
Because we're not the national park.
No, that's because that's when you get to this.
Yeah.
So
Yeah.
it'll be a national or regional.
Yeah. We're not, those views are not national views.
No, exactly. Finger in too many pages. All right. Yeah, brilliant. I will ask, I think, clear from the questions I ask.
Yeah.
Yeah. I mean, Joe said so. I mean, I'll ask you to comment on the oral evidence that was given now, because we've only been getting for the first time any sort of explanation as to how it was arrived at, for example, a high value susceptibility for the appeal side. So that's what I'm asking. We can want. Yeah, well, I don't need to do that. That's clearly established. That's why we're just going to focus on the appeal side. So it's the assessments relating to the appeal side. And yes. And that's the point you want to make.
I just want a lot more out of it. But the general is good. Oh, absolutely. That was the planning inspector what we really instructed all of them. Although the inspector.
Yeah, they don't want them in their own back.
Oh, no, no, yes. So the appeal is for the access. Oh, yeah. Yeah. And yet we've hardly spoken. Well, yeah, yeah. So my view is made it clear as a public code. We are not objecting. The objection to the access of our residents. You know, that's the key word really that we're not need to be because we actually need to. Very nice. What area?